We have 2 items on the agenda. I will tell you, and I apologize for this, but I am on call with my job in case there's a murder in Sussex County. So I have my phone, the ringer's low, but it's on, so hopefully I won't get called out, but just as an aside. If everyone can see, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So we do have a quorum with just the 3 of us, but unfortunately our other 2 members were not able to be here tonight. I have Dave Vogt and Rick Hardy and myself, Julie Jumper, Randy Wise. Sorry, Rick's the one that's not here.
That's right.
Sorry, I can't believe I did that. Randy Wise. Sometimes my brain, it's been a long day. And we have our acting town attorney.
Yes, Richard Forston.
Thank you. And also present in attendance is our town manager, Bill Zolper, our assistant town manager, Jim Dedes, and our town attorney, town solicitor, Fred Townsend. So, we have the minutes from our last meeting that took place on March 25th, 2026. All the members of the board have got those a few days ago. Do I have a motion to adopt the minutes?
Motion to adopt.
Second?
Second.
All in favor?
Aye.
Aye. So the minutes from the last meeting have been adopted. The board members have also gotten a copy of the agenda. Do I have a motion to approve the agenda?
Motion to approve.
Second?
Second.
Aye. All in favor?
Aye.
Aye. Okay. And the public notice attestation about that this was published according to the rules set forth. The hearings were published on the Cape Gazette on April 14th, 2026, and the proper notifications were given. So the first real item on the agenda is the public hearing, which is a request for an appeal from the building official's interpretation that 185-51A and 185-92A2 of the Code of Town of Dewey Beach prohibit the construction of a 4 1/2 foot pool safety fence in the 18-foot front yard setback, as such height exceeds the maximum allowable fence height of 3 1/2 feet permitted within the front yard setback. This request has been submitted by Veronica Faust, Esquire. So we're going to go ahead and open that public hearing. And this relates to the property at 101 Carolina Street in Dewey Beach.
Okay. At this point, you can tell us why we're here. At this point, we're going to get a statement from the town manager as to how we came to be in Close Spring.
Thank you.
Yeah, Bill Zolper, town manager. I've been employed with the town of Dewey Beach a little over 5 years. Early December, there was an application that came in for a swimming pool in the front yard at 101 Carolina. At that point, Jim Dedes was handling that, and it was turned over to our council, and it was denied. And then after that, Ms. Scheck asked to meet with us, myself and Jim and the mayor, and after consulting with Jim, we decided to meet with Ms. Scheck and her husband, Rich, who was seated in the room here. We met with them on the 18th, and then we met with Jim and I met after that, and then on the 22nd, I called Ms. Scheck and told her that I had approved her putting the 4 1/2 foot fence in the front yard. And then on the 14th of January, I called her back and said that after further consideration, consulting with our council, that I had changed my mind and that she would have to find relief elsewhere, and I was denying the 4.5-foot fence in the front yard.
At this point, we're ready for their presentation, Fred.
Well, I think what we've agreed to do in discussions is that we're going to first enter some facts into the record and then move to argument after that.
Okay.
So, I don't know that I contradicted anything you just said. So I know that there are gonna be questions of the town manager, by, Ms. Faust. And then Ms. Faust is going to, I think, call some other witnesses, and then there'll be some cross-examination, if you will, or redirect from me. And I may call a witness, or probably will call a witness that the applicant will not call, and they'll have an opportunity for cross-examination at that time.
And who would that witness be?
Pardon me?
Who would that witness be?
Kate Banaszak, the town clerk. You've indicated to me, not right this second, but you've indicated to me that you intended to ask questions of Mr. Dedes, and if you
Yeah.
don't, I won't.
And I don't know if we were gonna do that in context. I think he wanted us to put on our case and you were gonna do some facts and I could either question them in connection. You wanna put on your facts first? You want us to put on ours first?
So let's do it this way. So the appellant obviously goes first. The burden's always on the appellant anyway. And so why don't you give a very short statement? I assume it'll be consistent with what the town manager just said about what it is you're appealing. Briefly describe, give us a roadmap of the witnesses you're going to call, and then we'll let you call your witnesses. Then we'll let Fred get up, call whatever rebuttal witnesses he wants to call. He'll give a short statement about who he's going to call and why. And then once all the witnesses have spoken, then we'll return to you and you can give your legal argument about why you're right and the town is wrong. And then Fred can get up and say why the town is right and you're wrong. And then as the appellant, you get the last word.
The only thing I would ask is with respect to once he puts on facts, that I have the opportunity to also cross-examine.
Oh, yeah, certainly. Yeah, certainly. So after you examine your witnesses, Fred can cross. And then when Fred's done examining his witness, you can cross. So with that, why don't you start?
That's great. Can you put my phone? Do you mind, do I have to go up to the podium?
Wherever you're most comfortable.
I'm fine with you there with the mic, as long as you have the
Are
microphone
you
so that
fine?
it can be heard over the live stream.
Thank you, and I will have, I'll share it with Ms. Scheck. She's gonna be my first witness. We've got a lot of paperwork here. So for the record, my name is Veronica Faust. I am an attorney with the law firm of Morris James. I am here today with Marcia Scheck, who is the principal of 101 Carolina. And she, we're here today because she applied for a building permit for a pool. That building permit was denied by the town, and Ms. Scheck believes that that denial was an error. And we're here today for the BOA to determine whether in fact that denial was an error. I'm going to refer the board to the denial letter that was issued by the town. And I wish I had it at my fingertips. It's right here. It is the last document that is attached to the application. I can't put my fingers on it. Oh, sorry.
It's the last, yeah, it's the last. Memorial.
Where's the denial? And anyway, I can't put my fingers on it right at the moment. The denial letter basically denies the permit on the grounds of 185-51 A and 185-92 A2, all right? And our contention is that those were not legitimate grounds for denial. All right, so Fred, do you want me to call my first witness?
That's fine with me.
All right, at this time, I'd like to call Marcia Scheck.
Just so it's easier, why don't we have any witness sit in this chair with this microphone? And that way,
There?
yeah, so that
I just,
questions you can answer and we can all hear and you're not hidden away. Try. And then for the record, I think we ought to swear you, so do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Thank you.
So, Marcia, again, could you give your full name for the record?
Marcia Schick, 1430 Bayard Avenue.
This is why I needed a tape. Thank you. And Ms. Scheck, are you, what is your, how are you connected with 101 Carolina?
So I'm the principal owner of 101 Carolina. It's a land lease property I purchased in 2017. It was a conjoined lot with 103 at the time, and I split the two lots in 2017 into two deeded lots.
Okay. And did you indicate that those lots are leaseholds?
They are. They're both leasehold.
And so what does that mean about them being leaseholds?
So in 2017, we were given a 60-year land lease that started at around $18,000 per year per lot. I think that's up to about $26,000 a year per lot, so collectively $54,000 between the two lots.
So at one point, you were using 101 Carolina as part of your yard, is that correct?
Correct. So
And when did that happen?
yeah, so when I purchased 103 Carolina, it was pretty much as close to an abandoned property as you could get. And once I split the two, I had to tear off about 6 inches of the entire side of the east house so that it would comply with the setback. We had to go from the front and cut off 6 inches to the back for compliance. We essentially tore it down to the studs, literally taking off all the T111 and rewiring, replumbing, reframing, and bringing that cottage back to what its original character was, but preserving it, but also making it livable year-round.
And did you live there at one point?
I did. I lived there in 2018 for about 2 years after my husband passed away in the spring of 2018.
And you were indicating that you renovated that house.
Yes.
Is that what you do? Is that what you do what do you do in terms of?
Yeah, that is what I do now. I did have another career in Washington, D.C. for a long time, and by around 20 years ago, I started renovating houses full-time. I've done about 32 houses in Dewey Beach. Pretty much 29 or 30 of them are in the north end. So I have, of those, 28 were old dilapidated cottages that I was able to bring back to their original charm and make them year-round houses.
You're very familiar with building process here in Dewey Beach.
I've started buying my first cottage about 35 years ago, learned a lot, and yes, I became very familiar. I've probably received about 300 or 400 building permits in that time from the town.
And so I want to point you to, do you have the slideshow? I want to, I'm sorry, we have slides, and unfortunately we have to use we can't control our own slides. So I want to indicate, point you to slide 3.
also looking here. We can see it.
I'm good.
So I was gonna
Yeah.
hold this up, I think. So, Ms. Scheck, is this the survey that was attached to your application?
Yes, yes, it is.
Okay, and so essentially, can you explain where the fence in question is that is in dispute?
So the fence in question is the pink line. You're going to see extends across the front and then down two sides until it would meet where the 7-foot privacy fence is permitted.
And the fence that you intended to build was going to be how high?
4.5 feet.
Okay.
It's the minimum required.
And I want to point you to the next slide. No, next slide. Where's this house? Okay, good. Okay, there we go.
That one.
Yeah, I'm going to point you to slide number 4. And I would like to take notice that the survey that we just showed you was part of the application, so that should be part of the record. And this is,
Not the marked up one though, right? The,
well, not the marked up one, correct, but it's the same, we just did that for that, not for
Understood.
anything.
understood.
Yeah.
Mhm.
So the next slide we have is the slide that's presented. And can you show what this slide's going to show?
Okay, so this is the actual rendition of what the house will look like when it's done. It's done to scale, positioned on the lot from the street. What you're looking at is the front of the house. The left slide is where you can see the 3.5-foot fence, which is what the town claims is permitted on, and then on the right side, you can see the difference with the 4.5 height fence. The parking as shown is actually as it's applied for. We had to have 3 parking spaces, so I have 2 down the side, 1 in the center, and that's primarily because on a corner lot, you have to be 40 feet from the end of the lot line to the entry of your parking space for right-of-way and flow. So we really had to put 1 horizontal in the front.
And your lot backs up to King Charles Avenue, right?
My lot is on the corner.
Backs up on the corner.
Carolina, it faces Carolina, it's on the corner, it fronts King Charles on the east side.
Yeah.
Correct.
And so can you tell me what lines King Charles Highway or King Charles Avenue on, in terms of,
Oh, the topography?
yeah.
So King Charles is mostly from Chesapeake to about West Street, a 2-lane highway that is the entry into Rehoboth by the Sea, the neighborhood it's called. And it's primarily lined with bamboo and evergreen growth, loblollies, other kinds of wild evergreen growth that has come out wherever it does. And I think one of the things that's really nice about that part of town was back in the early versions of the comprehensive plan, back to almost 2007, one of the things that they emphasized was they wanted to keep that entry to Dewey Beach green and keep the topography with the sides green on both sides of the street.
So I want to talk now a little bit about your application for your permit. So can you give the board please some history on how that all transpired from your perspective?
For 101 Carolina?
For 101.
Okay, sure. I started meeting with Evergreen Homes, which is the contractor for the home. I've built one other home with them in Rehoboth. I started meeting with them, I think I signed a contract with them around January 2025. which is really required. I know it sounds odd, but it's really required because a builder won't start to meet with you and do construction plans unless you've signed a contract and given a deposit, because it's a considerable amount of time from the time you start to having plans ready to present to the town. I started meeting with Evergreen during the spring and summer of 2025. I'm pretty sure we started meeting with the town around August or September of 2025, going in with Evergreen with sort of what was our finalized plans to start our initial review. And we did a couple meetings with the town. I think we were pretty final on our concept by September. At that meeting, I did have the pool as part of the contiguous application for the house because it was essential of where we were locating the house in the pool in the design plan for what they were contracting for excavation and everything else. So those, we needed to make sure that was going to be finalized. At the last meeting we met, the pool was at the same location, the fence was at the same location. This was in September of 2025. And I think the only objection or change the town asked us to make was to remove the outdoor shower or remove it from being part of the structure for a setback issue. So we did that, and then we proceeded with plans, and then at some point around October, maybe early November, Evergreen let me know that the town had asked them to remove the pool from the plans, that the pool would need a separate application as an accessory structure, and they wanted that to be removed from the plans as two separate applications.
And had that been your experience in the past when you did a pool?
No, and I don't believe that any of the permits I've looked at with new constructions with pools were separated. They are usually together as part of the pool plan, as part of the whole lot plan.
All right, so they asked you to separate the plans, and then what happened? What did you do?
So we separated the plans. I mean, that's what they wanted us to do. I was not in favor of it because the whole contiguous structure of 6 months of planning for the house has been based on the house location. We had to do soil tests and different points in the soil where the house is going to sit, where the pool's going to sit. And we pretty much had that all finalized based on the early on meetings with the town, meaning August, September versus getting our final permit in November, December. So that's why it was really critical to me that we not separate it. It was part of the whole structure of where we were with our site plan.
Right, and why was the timeline important?
Well, the timeline's important because it's contiguous altogether. The builder is working with the pool company, determining when the pool plan, the pool dig and construction can start. A concrete pool takes about 3 to 5 months to build, depending on weather. There's a lot of curing of concrete and waiting while concrete is curing. The builder has to coordinate with the pool company because they can't have the digging occurring while they're having construction materials, and especially things like drywall. They need a place to put it. They need to be into the house before the pool company starts to dig. So it's an extensive planning process. I mean, building a house from the ground up, it is an extensive planning process. And I want to say, for me, I did my first one about 2 years ago, 3 years ago. Most of mine, almost all, have been full renovations of old cottages. So I really did learn that the coordination is critical, and that's why I did not want to separate it.
All right, so, but you did wind up separating it.
The town really insisted on it, and we did.
All right, and did you commence construction on the house?
We commenced construction on the house, I believe, in early January.
And what's the status of that construction now?
It's about half finished.
Okay.
They're starting drywall.
All right, so let's go on to your pool permit. So talk a little bit about what your perception of is what happened with your pool permit.
Okay. Well, and pardon my, I have to make a timeline. There's a lot of moving parts for this. And I have some other things going on with construction too. The pool permit was, okay, December, so after the town asked me to separate it, I applied for the pool permit on December 3rd, 2026, with the filed pool permit site plan, which you showed
mean,
before.
2025.
2025, sorry, with the site plan you showed before. I don't think it was anything new to the town, because we had been discussing it when we brought in the full house permit, the location. The location of the pool, the size, the fence, everything stayed the same. We didn't make any changes to that. I just separated it out into a separate permit. So I submitted that December 3rd. Around December 4th or 5th, I got a call from Mr. Dede saying he didn't think they were going to approve the fence location. And that was really concerning to me because we were into construction. There was no going back now. And I had paid my initial fees and some very large deposits. And now I'm hearing my builders saying we got a real timing issue with the pool. And we're already taking trees out that were permissible by the code, and we're starting our excavation. It has a basement, the house has a basement. So the reason why it really couldn't be moved after that was that we had plans and contractors already in place for excavating the basement down 8 feet.
All right, so what happened next?
So on December, yeah, okay. So that's December 4th, December 5th through the 16th. Jim and I exchanged a lot of calls back and forth on how do we make this work? What do you need from me? We talked about, a lot of discussions about the code and the permissibility of the pool fence in the front yard. We went back and forth with discussions on the code a lot. The town's perception of the code at this point was very different than ours. And it was very different than when we brought the original plans in with the pool. There was no objection to the pool where it was placed when we were there a month ago, and the fence where it was placed a month ago. So that was a little it was really worrisome to me.
And
So
did you engage counsel at that point?
Yeah, so because of that and because of the timelines and the money that was already invested and the builder's timelines, I talked to you, and we talked about getting Steve Spence involved because he was available. It was critical. I needed something very soon to figure out what we were doing. Steve Spence in December wrote a letter to the town highlighting our position, that we
May I
are.
interrupt you for a moment, Marcia? That's exhibit 2 to
Okay.
our submission.
Okay. Basically highlighting our position that the pool safety fence has been code compliant in the front required yard since a decision made in 2013 by a board at a similar hearing. And I think Steve also, cited some case law that the town has never changed the code or changed the position on that. And we've always felt like the pool fence was always compliant in the front yard. I want to say, quite frankly, for all the construction I've done and to understand how critical it is for timing and timelines, I have no interest in putting something somewhere that's controversial. In all of the time that I have been doing this since 35 years, I've more than 300 or 400 permits. I've never once asked for a special exception. I've never once asked for a variance, and I haven't been granted any.
So let's, you're going on you hired Mr. Spence, he wrote a letter, then what happened next?
So Mr. Spence wrote a letter to the town, and then I called Mr. Dedes and suggested we get together to review the decision from the 2013 hearing on the very same application of whether the pool fence in the front required yard is code compliant or not code compliant. That hearing resulted in a 4-0 vote that the fence in the front yard was code compliant, and essentially was not in a violation of the code.
All right, so we'll get to the 2013 matter in a minute. Let's get through the permit
Right,
process,
so
and we'll go
what
back
we
to
want to
that.
do was hopefully take time where myself, my husband Rich, who, despite the fact it's my business, he by default had to be brought into it when I married him 3 or 4 years ago after our respective spouses passed away. We're both widows. Basically, I wanted to go in and just try to get things back on track so we could get the project finished. So we went in on the, I think, Bill, you said the 18th, I had the 16th, I don't know, it was pretty close, right?
Yeah.
We went in around the 16th or the 18th, probably spent an hour, hour and a half together, Mr. Zopler, Mr. Dedes, myself, and my husband Rich, who's here, and just sort of went through all the documents, went through the code, went through our positions on all the code sections, looked at the 2013 hearing stuff. They had said they consulted with, their town solicitor, and we just hope we had a resolution that we can move forward and get past this. It was a good meeting, we'd always rather resolve things that way. This kind of stuff is very expensive, it's very time consuming, and I thought we were in a good place after our meeting. After that, so probably a couple days went by, I had the 16th, I said, on December 18th, the town, Mr. Dedes wrote an email to Ron Wilkins, the head of Evergreen, saying you can get your county a permit approval. We'll review the plans, and if okay, meaning no major changes, we'll issue you the permit. So December 22nd, Mr. Zobler contacted me by phone to report that they had reviewed the substance of our December 16th meeting with the town attorney and also consulted another land use attorney, and they were in agreement that they were going to approve the fence as code compliant. And they were going to work on the referral letter. That was the 22nd. Then December 30th, I called and basically said we were leaving town in early January. Could I get the referral letter? And Mr. Dedes did get the referral letter on the 30th that day for me to take to the county code. We took it, that was the day before New Year's, and they closed early at the county office. So we took it on the 5th, and we got the county, I paid the permit fees to the county. I got the county permit issued, and we returned it back to the town.
So for the board, we just want you to take note of Exhibit 6A through 6D, which are the paperwork. It's on the screen, but it's also in the packet that we submitted in advance of the hearing, and these are the documents related to the county building permit that she received and applied for, and the referral letter from the town. So, Marcia,
I can say that once we got the go-ahead from the town, I think one of the things you have to understand in Dewey, we all know we're a little honky-tonk and a lot whatever we want to be, and we're a lot hands-off in terms of how we love our streets and love our atmosphere and everything in town. And Jim and I have had a really great working relationship with a lot of permits and activities being approved over the past 5 years. Jim does a lot of handling of my permits, and there's a lot of trust in that. I mean, there's a lot of trust. There's a lot of trust when someone tells you, you're good, go, contact your builder, contact your pool person, we've approved it, you're good, don't worry, we're very busy in town hall, we're going to get the referral letter out to you soon, but you're clear, go. That's a lot how we operate here. And so once they told me in December on the 22nd that we're good, we're clear, we can go, I informed the builder, the pool company, we made deposits, we made additional deposits, we were clear for the excavation, and that went forward. So that was pretty much up to getting the county permit on January 5th.
Then what happened?
So, from about, I'm thinking the end of December to the middle of January and probably beyond, the town received an extraordinary amount of letters, maybe, I don't know, 4 or 5, from 2 individuals that were somewhat spearheading, what it seemed to be was spearheading a resistance of my project or wanting to, asking the town to stop my project completely, essentially, the construction of the house, everything. It was a little disturbing because a lot of the letters, most of them had about 90% inaccurate information. So these letters are going out to people in mass format with statements that I didn't have approvals for tree removal, my house was going to encroach into the front yard setback, the pool was going to be in the front yard setback. I was given exceptional variances and special exceptions that I shouldn't have been granted. That's really disturbing because to me, that gets resolved by a conversation. And as soon as I did a FOIA, and soon as I saw the letters and where they were coming from, I contacted both of those women and said, please reach out to me, come to my house, see my permits, we can meet at town hall, call the town. The information you're putting out is not accurate, it's harmful, it's not helpful, and it's causing a lot of strife, not just with the town, but it's penning neighbors against neighbors. And I invited them to come to my house, meet me on site. I would have all the applications, all the permits, so we could get this corrected and it could stop. Both of those women declined. And it continued. It continued for about another month or 2. And the information continued to be inaccurate. So,
How did you, whatever happened with your permit?
so on January 10th, as part of my FOIA, so basically I did a FOIA requesting communication so I could understand what was going on. As part of my FOIA, there was an email from the town manager to Mayor Stevens after approving the pool regarding the fence, stating he had reviewed, and this is not verbatim, but you guys have copies of it. He had reviewed the attachments that Rich and I presented at the meeting, which would have been the transcript of the vote of the 2013 hearing, emails from Commissioner Rorden then confirming that the pool fence was legal in the front yard setback,
I
and,
think you're talking about 2013, aren't you?
yeah, sorry,
yeah,
yeah, I'm sorry, I'm sorry. And,
So let's go back.
Go ahead.
So you were talking about there was strife in the thing, and then you were told you were gonna get your permit. How did you find out your permit was being revoked or not being granted?
yeah, so I got a call on January 14th from the town manager saying they had reconsidered the approval and they weren't going to be able to approve the fence anymore. This was after the county permit. This was after the referral letter to the county. I paid the county permit comes back. And essentially, to understand that process and what you rely on in good faith is the referral letter, the building application to Dewey is the start of your review from local municipal codes. Once Dewey gets your packet, they review that you're in compliance with the codes in Dewey Beach. Then they issue a referral letter to the county, which basically says, county, we've reviewed this and you're in compliance you're free to now get your county review.
And what's a county review for?
County review basically reviews for any kind of code that Dewey doesn't have control over. So Dewey's code would mostly, at the Dewey level, it's mostly going to be things like setbacks, FAR, height limit, parking,
So
all
zoning
the,
issues,
huh?
zoning issues.
Zoning issues, all the low-level zoning issues. The county's more building construction for the pool. They want to see actual construction plans for the pool. They're going to have inspections along the way for the pool. So the county overrides Dewey to a higher level at that point. So now you go with a referral letter, which says, we have reviewed, we're local compliance with Dewey code. Here's the referral letter, pay your fee, get the county permit, come back to Dewey. Once you get back to Dewey, it's pretty much a perfunctory issue. You get the Dewey permit because you've already gone through the approval, gone to the county, come back. The only time that generally Dewey wouldn't issue a permit after the initial review and the county review are a couple of things. You had a fraudulent application, or something on your application was fraudulent, and they found it to be fraudulent, or the county requested a change based on like the International Building Code, which the county controls. So if the county would have said, hey, your pool electric wiring is not up to code, we need you to change that, that's not something Dewey would deal with. So we would have changed that. So then that would come back to Dewey, and Dewey would say, oh, okay, it didn't affect anything we've already approved. That's generally the only two circumstances where you wouldn't get that. And what I want to say is really significant about that is Dewey approves between 500 and 800 permits a year. I think that's, Jim, what you stated in one of the meeting, 500 a year. During one of our meetings, I asked, when we were trying to resolve this, I asked Jim if they had ever, in the lifespan that he's been here, which seems like 100 years, I know it does. Anyway, I asked, have they ever denied a Dewey permit after the initial review, the referral letter, the county, and coming back? And he said never. So over his 15 or 20 years, that's like 7,500 to 10,000 permits, and not ever refusing to issue a Dewey permit after the county permit was issued.
So you got a call from Bill that they were not going to.
They were not going to issue the Dewey permit. Essentially, for me, that meant they had already reviewed it, and they were revoking their approval, their past approval.
Anything else about your conversation with Bill that you want the board to know?
Well, yeah, it was a little disturbing. So when I got the call on the 14th, I was pretty surprised that Bill was telling me they weren't going to issue the Dewey permit. Essentially, the only thing he talked about was there was just too much pressure from property owners that didn't like what I was doing. And it was too much political pressure. They were getting letters. There were a lot of people that didn't like what I was doing, and they were going to ask me to go to the Board of Adjustment. And I mean, Bill apologized, but my response was, zoning's not a popularity contest. We've been through this. This has been approved. And telling me that you are going to revoke the approval because too many neighbors don't like my project and don't like what I'm doing, I actually said on that conversation, it was about 30 minutes, that you've mentioned nothing about non-compliance with zoning, nothing. All you've said was there's too much political pressure and we're going to have to ask you to go to the Board of Adjustment. That's a big hit when you've trusted the system, when you've trusted the process, when you've trusted the approvals, and we have a lot of money and time and effort sunk into building plans and deadlines that included for a year of planning, knowing that we would start the project in late fall to early winter so that within 6 months we could finish it by the rental season in June and start our rentals to get back some of our investment as we went along.
So, Marcia, you said you were doing some FOIAs, and during that, did you uncover any evidence in your FOIA submissions that was indicative that there was some political pressure?
Oh, yeah. There's, so I did a number of FOIAs, mostly for communication to understand what all the letters were. Basically, I think my first one was anybody who has made an objection against my properties, any of them. And I got about, I don't know, 500 or 600 pages of communication. A lot. That's where I discovered all the information that was being written that was not accurate. And listen, I could understand if I got a letter that contained the information that was in it that was so wildly inaccurate that I'd been given all these variances and special exceptions, and my house was going to be in the front yard almost to the street, and the town was permitting that. I also saw emails between town officials that was a little troubling, talking about my property and the approval. So there was one email that basically was on January 10th, if I remember it, from the town manager to Mr. Stevens, saying he approved the project, it's
And is
code.
that the email that's up at Exhibit 4? Or she needs some glasses.
Yeah, I know.
Yes.
Well, it's not the first email. I don't see Bill's email, but basically, that was the letter that the mayor got from Ms. Souza. She was one of the women that was spearheading this. And I guess the email was from the mayor to the town manager the 14th. So the email from the town manager to the mayor said, I've approved it, it's code compliant. That same day, on the 10th, the mayor said, I agree with your decision, that for the approval. The mayor said, I agree with your decision. 4 days later, the mayor after getting another series of all these emails about my alleged violations, then the mayor came back and said, these issues are compounding and it's not good.
And what date did you get your notice
That same day, about 2 hours
that they
later.
weren't going to issue your permit?
Yeah. Yeah.
So what happened next?
There was an email in between the 10th and the 14th in the FOIA where Commissioner Persinger wrote to the town manager, basically saying there's a lot of criticism going on about this project and the town. A lot of these emails were very critical to the town, saying that the town's not enforcing code, they're giving out special exceptions to this property owner, she's had all these exemptions, she was permitted to take trees out that weren't permitted, none of which was true. And I think Mr. Persinger said, how are we going to address these criticisms? I understand that. It wasn't just about my project, it's about how the town was perceived to be handling the project, which quite frankly was also inaccurate. The town was not giving out special exceptions or allowing anything that wasn't to be code compliant. I know the code pretty well. I've been a volunteer in this town for a long time, and I've been building for a long time, and I can tell you one thing I do. I get a permit whether I meet the minimum level or not, because it's not worth it. With everybody looking at what you're doing, $50 is not worth it if I have $2,000 of work. It's just better to have it. So,
All right, so let's go on. So you get your notice from the town, you get your call from Mr. Zolper that the town's not going to issue the permit. Can you tell us a little bit, you were talking earlier in the discussion about a 2013 hearing.
Yes.
So I want to know, I wanted you to give a little explanation to the board about how that 2013 hearing impacted your decision to make the application that you made here, and how you think that 2013 decision was essentially, you know, precedent for you receiving the very application that you've applied for.
Okay, yep,
Is that calling for a legal argument from the witness? I mean, I understand you want to talk to her or ask her questions about the 2013.
I think she needs to lay, so we can make our legal arguments. I think she needs to lay the ground for what 2013
But
has
you're going to
done.
make a legal argument as to the
I
significance of.
I'm gonna make the legal arguments, I'm gonna ask her about the facts surrounding it. She's not gonna make legal arguments about the 2013 hearing, but, so if you could just tell everybody a little bit about what were the facts behind the 2013 hearing?
so in 2013, I had purchased 114 Chesapeake, which does have a pool currently in front of the house. The pool is located within the buildable footprint, and the fence is located in the front setback, 15 feet from the front property. Setback's 18, the front's located 4.5-foot fence, 15 feet back. While we were under construction, a neighbor filed complaints to the Board of Adjustment against the property, against the pool, against the fence. Honestly, there were a whole series of complaints. But I think mainly it was just the pool. And that went to a Board of Adjustment hearing. It had a full evidentiary hearing, so there was testimony. And the board ultimately basically said the applicant had no standing and it was filed late. So,
I'm sorry. So you can correct her if she's wrong.
Okay, it wasn't the Board of Adjustment that held that hearing in 2013.
it was.
It was not.
No, it was July of 13. There was a Board of Adjustment hearing before the November 13 hearing. I have the transcript.
I'm sorry, I guess I'm confused.
No, we were talking about July. So after the complaints were filed, that neighbor filed,
She's giving more background, asked about the 2013 hearing.
he filed a
Yeah,
Board of
she-
Adjustment appeal. That was heard in July of 2013. And
I'm sorry.
yeah, that's okay. And then July 2013, after that hearing, the then town manager told me we were clear, everything was clear, we could continue our construction on the pool with the fence where it is, everything. We go through that. The same neighbor filed another complaint directly with the town manager, and then through a series over a couple months, somewhere around the 3rd of October, the town issued a letter saying that my fence was not compliant. Well,
Because of why?
because it was in the front yard setback. So that letter, then we filed an appeal.
And where did that appeal go to?
That appeal went to the November 9th, 2013 hearing that was held here. The board was the town council sworn as in a judicial setting. It was a quasi-judicial hearing. And they were basically asked to answer one legal question, which was the fence at 4.5 feet code compliant or not code compliant in the front yard setback?
Right, and that was in the context of a threat to revoke or rent.
Yeah, so the letter basically said your fence is not code compliant and you have 10 days to correct it or I'll suspend your rental license.
So what, and then you went to the hearing,
Mm-hmm.
correct? And what was the outcome of the hearing from your perspective?
So there was a motion for a call whether the fence was legal or not legal in the front yard setback. And the motion was 4-0 that the fence was legal in the front yard setback.
And did you
And I
get-
think you have the transcript of that.
Yeah, so we're going to ask that the board take note of exhibits that we have on this, there's exhibit numbers. Exhibits 3A, 3B, 3C, and 3D, which were part of the packet. Okay, so those were part of the packet that were submitted to you, and those are the documents that are relevant to the 2017 hearing.
Yeah, just speak to that.
Yeah, you can, yeah.
I don't want to interrupt, but
Yeah.
regarding that transcript, it was not prepared from a recording that was made by the town. It was apparently prepared from a recording that was made by a member of the public. I'm not saying that that recording was inaccurate, but the transcribing of it is purporting that a number of people made remarks that didn't make those remarks. I mean, there's nothing inaccurate about the dialogue, but the dialogue's attributed to the wrong people again and again and again in that.
And that may very well be true. Okay, that very may well be true, that transcript. Apparently, there were a lot of places that it was inaudible. So the town, so explain how you got the transcript and why
Yeah,
they-
so, and Fred, you're right, there are a lot of places it's inaudible. And I think they did the best they could, but what happened was the town was required to record the hearing itself. And I think at the beginning of the tape, you hear them saying, "Mr. Mears, are you ready to record?" And then after the hearing, I requested the tape of the hearing, and they said that it was damaged or lost. They couldn't find it. So I think Mike McDermott, the attorney at that time, went back and had the town ask for an email from Commissioner Reardon on what the vote was for, what the question was asked, to confirm that at least the vote was correct. And I think you have that email.
And that is Exhibit 3D, I believe. Exhibit 3D. So that was the email that the town's response about what.
And so where the tape came from, there was an independent reporter that came to most of the hearings, and she made copies of all the hearing tapes. And unfortunately, she passed away about, I don't know, a year or so after that hearing. And I reached out to,
We don't object to the
All right.
transcripts or.
All right, so we don't even need to
Okay.
do that. We'll just,
okay,
it came
perfect.
from a reporter.
Came from a reporter.
We can have that for the record. And then we had it transcribed, and there were there could be plenty of inaccuracies in it, because,
Names.
yeah, nobody knows it was 10 years ago.
13.
And I don't know who that John Forston guy is, but
Yeah,
I know
yeah.
Richard Forston was there.
Exactly.
you John?
That's the way the transcript has it.
Yeah.
But for the record, I mean, since I was there, I mean, the finding of the commissioners at the time was the code was ambiguous, and therefore the fence was allowed. So that was the basis for their finding and allowing the fence to remain and then restoring the business license.
All right, so, Marcia, can you just say a little bit about, after that hearing, what happened next?
Yeah, so after that hearing,
I'm sorry, which hearing?
The 2013 council
November
hearing.
2013.
Yeah. And what the facts that we're getting at now will be important as we discuss the argument in this matter. But, so Marcia, you got your 2013 council hearing.
Yes.
You get the decision that, okay, they're not gonna revoke your
Yeah, they weren't gonna
rental license, and you're gonna be allowed to leave your fence.
correct, so that was November of 2013. Then in the spring of 2014, the town manager informed me that my fence was not compliant with the code in the same location from that decision, and that if I didn't move it and move the pool, that he would not issue my rental license for that property, but that he would not issue my rental license for my other 13 properties, which would have,
Is this,
per-
I gotta ask whether this is relevant to what we're trying to get to today. I mean, you're talking about the aftermath of 2013?
Yes, we are talking.
And, well, can you,
We're, just indulge us, we're only gonna take a few
can
moments.
you proffer what the relevance is?
it will become evident as we make our closing arguments, okay? It'll become evident as we make our closing arguments about this. So,
I've been generous because she's been reading from something you've given her up here, which probably she shouldn't have if she's going to be testifying. But,
Well, actually, these are my notes I gave to
Okay.
Veronica.
okay, but yeah, you shouldn't be testifying from notes.
well, I think
just
these are
without
notes that she
providing-
made contemporaneous with her, yeah. I mean,
I've had this
do you want me to make a
timeline.
proffer about how she's been testifying to this?
No, I'm gonna let it go, but I share, I mean, I lost the train of thought here. So we had the hearing in 2013, business license restored, and then something happened after that, is what you're saying?
Yeah, the town continued to allege that my fence that was approved was in violation of the code. And that continued for about a year and a half. And it got to the level where, because they were threatening my business licenses for all my properties to shut down my entire livelihood, that we had to file a federal lawsuit against the town. And that occurred in 2016. It got settled in 2018 with essentially before a magistrate judge, where the town made a settlement of $122,000 for us, paid our legal fees, pretty much, is it.
So, your position when you made your application with a fence, a pool safety fence in the front yard was what?
My position was very clear that the safety fence is permitted in the front yard. It's been permitted for a long time. The code is very clear. We've made that argument many, many times. We don't have any position on ambiguity, quite frankly. The town has not changed the code since 2013. It was decided that the fence was legal in the front yard. I would have had no reason to believe when I was planning this house that there was going to be a controversy.
So let me ask you this, is the code the same today as it was in 2013 with regard to the code sections that you've been denied your permit based on 18551A and 18592A2? Are those the same code?
The code's exactly the same, except for a recent change that was entered into, I think, in March.
And that was after your permit was denied?
Yes, of course.
Okay. But at the time of your permit, those code, you had applied and were denied, those code provisions were the same?
Exactly the same.
All right. And I want to, we're almost done, and I indulge everybody for time, and you guys, this is really complicated and long. It's really complicated and long for the attorneys, I can tell you that. So the other thing I want to ask you is, you've read the legal arguments in connection with these proceedings, right? Both offered by me and offered by Fred, or offered by the town. And you are familiar with the interpretation of what they've proffered about the green space ordinance precluding pools in the front yards, right? Okay. So the one thing I wanted to ask you is, are you aware, are you familiar where any front yard fences, have you been denied any front yard fences as a consequence of this green space ordinance 643?
6:30,
634.
or is it 8? No, it's 8:43.
Yeah, that's the other one. Oh, yeah, 843. So, have you been denied any fences in the front yards on the basis of that? Have you been denied any in any of your bills, any platforms or that are encroaching in the front yards, or porches or anything of that nature?
No.
And have you built any projects that would encroach in the front yard?
Yes.
Okay, and what have you built?
So I have built 4 houses on Jersey Street. I think you have it up, that all have the I think it's section 185, correct me if I'm wrong, 49D, that allows open, unenclosed porches, platforms, paved terraces, something else, to encroach into the front yard setback up to 5 feet, not to exceed, there's a couple levels of this ordinance, not to exceed the first floor of the house level from the ground to the house, but no higher than 4 feet, and no closer to the front property line than 6 feet. So it's kind of a little, it's a little bit of everything. It's if your house is pushed back, if your house is pushed forward into the setback, you get some of that. But that code basically says that you can have sort of 5 elements of that, at a minimum encroaching into the front yard 5 feet. But if your house is actually already into the front yard, you can go up to 6 feet within the front property line. So so let's say you go to the 6 feet, you could be 4 feet high, 6 feet from the front property line. The issue with that code and where it contradicts other code, meaning the 3.5, meaning the town's saying there's nothing permitted in the front yard setback above 3.5 feet, that's just simply not correct. Because 18549D allows an encroachment up to 4 feet high, as close as 6 feet from the front property line. Now, the unintended consequences of that is if you have a platform or a deck or an unenclosed porch at 4 feet high, the maximum, if you are beyond 30 inches, the ICC code and the Sussex County code mandates that you have a 36-inch fall safety fence on those. And so you now could have 4 feet, 6 feet from the front yard setback, plus your safety fence, so you're at about 6.5 feet, 6 feet from the front yard setback. So there's just multiple sections of the code that do allow things over 3.5 feet in the front yard. And to make a blanket statement that nothing is permitted in the front yard over 3.5 feet, including your 4.5-foot safety fence, which is a mandated protection fence, the 3.5 feet fences are ornamental, they're optional. You can have them, you cannot have them. That code also, 18551A.
Marcia, we don't need you to testify
Okay.
the code, but what I want to know is, at 112 Jersey Street, what did you get?
So at 112 Jersey Street, you're showing all the Jersey Street houses. They have an encroachment, a permissible encroachment of 5 feet. I think it's 5 by 9 for a platform. And at 112 Jersey, I applied to put a rail on that in January because I have a long-term renter right now that are elderly and they felt uncomfortable not having a rail. So I applied for the rail. The rail was put up. That now is a height of 6.25 feet in the front yard setback with the rail. There it is. So that whole front section is the permissible encroachment into the front. It's at about 33 inches, and then the top with the rail, which is required, exceeds 6 feet high.
So what exhibit number is this? So we have exhibits that have already been submitted as part of our submission. So I don't know, do you want me, I would like to introduce this as an exhibit. So my question is.
What is this? Is this-
The plans for 112 Jersey Street.
So, about this, before we let it in, I've got a question about relevancy. It's dated September 9th, 2023. These are plans that were submitted prior to the adoption of the green space ordinance and reviewed prior to the adoption of the green
Yes.
space ordinance.
Correct,
So
but
you
the
may-
fence wasn't. That was submitted in January 2026.
Well, we're talking about this, right? So is this, so I would question whether this is relevant, because it's suggesting that this deck was permitted. I mean, I can't tell for certain, but it seems to be, it's impossible, it's very hard to read. to the extent that it suggests that you can have a deck in the front yard after the adoption of the green space ordinance, that's inaccurate because this was approved prior to the adoption of the green space ordinance.
Can I speak to that?
Please.
Okay, so that code is still in force and you can still have that encroachment. And when I went back to just review the FOIA, I got 2,700, my staff member got 2,700 pages of permits.
All right, but let's.
There are currently, in 2025, many building constructions that have approved encroachments like that into the front yard setback under that same standard.
Well, you say that, but you're not offering any evidence. But let me ask a question about the picture, just so I'm clear, the last page of this. The only thing, I think, if I read the permit that predates the picture that we're talking about, it says install handrail on front door exterior. So the handrail that is along the side of the building is what was installed.
No, it's the whole thing.
So the fence
It
also?
had no, yeah.
It had no fence? Okay, it just doesn't say that. Okay,
Yeah.
thank you.
All right, so I guess what, Fred, is the town going to take the position that because of the green space ordinance, and does the town take the position that since the green space ordinance was adopted, that you are not letting porches and projections into the 5-yard setback?
The town takes the position that the green space ordinance precludes your argument that a pool fence is permitted in the required front yard because a pool is permitted in the required front yard.
Understood.
Mhm.
And we have evidence here that we'd like to submit, and we did not know that was your argument until we got your argument, we got our arguments at the same time. We have evidence here to submit that there are the town has approved projections, they've improved porches, they've improved fences since the green space ordinance was adopted. And it's a logical conclusion. You try to and we're getting into argument here. So Rich, you tell us how you want to address this.
Well, look, here's what we're gonna do right now. Fred, I'm gonna allow this to come in as Exhibit 12. I mean, it is what it is. You can argue it's not relevant. And certainly to the extent, if you're relying on the green space ordinance and there's stuff that predates that, I wouldn't think it is. But there may be other stuff after the green space ordinance. So this has been marked Exhibit 12, and I think it should come in. I mean, we have a very generous evidentiary standard in front of the
Indeed.
board. So that's fine. So now you've got something else you want to
So
introduce.
I guess what comes to the crux of the argument is, and I'm making a proffer because we need to determine how we're going to do this. One of the town's arguments is that the green space ordinance prohibits a pool. And because it prohibits a pool, we cannot use the pool requirement under 8151B to say that a fence can be in the front yard setback.
A fence not higher than 3.5 feet.
A fence higher than 3.5 feet. So they're essentially bootstrapping a green space ordinance to the pool ordinance. The problem is if you take to the logical conclusion the ordinance that he's relying upon to say a pool can't be in the front yard, and you take it to the logical conclusion and you read it the way it should be read, it not only precludes a pool, it precludes porches, any things that are allowed in the 5-foot setback. It precludes HVACs. It precludes cornices, sills, and chimneys. Okay, because if you take the green space ordinance literally, like you're trying to apply it to the pool, it prohibits all of those items. And my point is, if you're going to apply, or our point is, if you're going to apply it to the pool, you have to apply it to all of the other items. But we have evidence through building permits since it was adopted that they're not. So the question becomes, do I need to go through every one of these? Do we want to submit them into evidence? We can look at them and we can agree that all of these have been issued? Or how do we want to handle this?
I don't know what you've got there, so.
All right,
Well, why don't you provide a copy to Mr. Townsend, let him take a quick look at it, and then see if he has any objection. Again, I mean, it's one thing to say that it gets admitted as an exhibit, it's another thing to say that it has legal relevance, and that's something that you can both discuss when you make your arguments.
Yeah, I understand.
I'm not quite sure.
Yeah, we'll go through.
Do you have a copy that you can show me?
We have them up on the screen, but we don't have a copy, I'm so sorry.
5 different copies.
Yeah, oh, these are 5 different copies, sorry.
Okay,
Sorry, I said that.
so we've got one. Good, I thought it was.
Let's not give them to the board until we decide whether they're coming.
I honestly, I don't know. We're looking at, that's, I don't know what the measurements are. See, don't send it over there. She said I signed it first. Okay, where's the, I don't know what you're talking about, so.
Is this the same property?
I'm assuming all this, Veronica, is this all the same property? You're showing me a
They
permit,
had head in there.
where's,
I'm sorry, what? I'm sorry.
is this all the same property that you just showed? Because there's a permit, there's an application, and I don't know what we're.
They have head in.
Yeah, they have headings, there's 24 Houston, and then you go to the next one.
So this is all 24, what's this?
Yeah. It's not copyright. Here's one showing, next one's one showing 22 Chicago. Did it not print right?
I don't know.
So
what
that's
We put
dated,
everything on one slide.
that's dated before,
It's in 2014.
that's dated before
It's a survey.
this, the green space ordinance.
Oh, yeah.
was adopted. So that's 24 East.
We'll simplify it for when I finally get a chance to kind of say what's an issue here, the lot of this is. Oh, yeah.
Christ, I have glasses, I can barely read it.
This is 2012 or 18 or something.
It's either 2016, yeah. That's the issuance of the permit on Chicago Street. I believe.
So the Houston is from,
No, I recall this one. I'm not quite sure what
Can I
the
look?
projection is this. Well, the front yard is over here. This was a really complex piece of property. We had to determine that this was the front yard.
So that's 12 feet. Is that in area?
Chicago's in the Downtown District.
Is this in the district?
Houston should be, which one is it? 24 Houston. Houston, part of it is in the resort residential. That's on the resort residential. It's a different, some of these aren't in the
But the green space calls
in our
So
district.
is this in the area?
I believe so.
Could I just describe one of these as an example?
No, let's
Okay.
really give them time to review and see what they're looking at
Okay, this was issued in January of 25. I'm not quite sure what it shows.
So,
Some of these don't show anything, some do.
I guess we're gonna need you to walk us through these as to what you purport to be relevant, because we can't guess as to what it is.
Well, if we can stipulate that the town, is the town taking the position that, I don't know, maybe we can stipulate to this to ease to move things along more quickly.
What they're proposing is we've allowed, code allows for a 5-foot entry into the setback for entry into the home with small decks. That's what they allow. No matter it allows it, and that was permitted. Okay. What they're showing is, I see what they're showing 5 feet, then the code doesn't allow 5 foot.
So Fred, let's talk to see whether we can stipulate to this. Is the town taking the position that the green space ordinance precludes hedges, fences, or walls 3.5 feet under 185-51A in the front yard setback? Are you guys denying front yard fences of 3.5 feet?
No, fences are permitted.
Okay, so that's what I wanna get at. So we can stipulate that the town recognizes that despite the green space ordinance, fences of 3.5 feet are allowed in the front yard setback.
Correct.
Okay, so
That's what the
stipulate
code-
to that,
that's what
that's
the code says.
stipulation number one.
Mhm.
Stipulation number two, can we just, despite the green space ordinance that we're referring to as, is it 634, what number is it?
843.
843. Can we stipulate that the town still allows front yard porches, platforms, steps, or paved terraces allowed by 185-49D in the front yard setback?
185-49D.
Let me pull it up.
I think I have a copy of it here.
If you have a
Want it,
copy,
Jim?
that would help.
Yeah.
It's having
You
difficulty
can't steal,
loading
you
up.
can't steal mine, but,
So,
here it is, here's the whole section. It's easy to follow, so I gotta read it on paper.
more than 5 feet, it does allow that.
Yes.
We'll
So-
stipulate, yeah,
So, despite the green space ordinance, you still allow porches, platforms, steps, or paved terraces in the front yard setback,
Yes.
correct? Okay, so that's stipulation number 2.
All right, just so we're clear though, I mean, again, I'm reading this ordinance. It says existing yard spaces covered with non-green space materials may remain but shall not be expanded. So, I mean, and again, I don't know, and you'll have to walk us through the permits, I guess, if that's what you want to
Well,
do.
I don't know, if we can stipulate these items, I don't think we need the permits,
Okay,
okay? Yeah, that's why I'm trying to get to the stipulations,
okay.
because we don't need the permits,
Is
if
it
we can
185-49D?
stipulate this. Okay, so the final, are you ready, Mr. Okay, so the final thing that I'm asking is, are you arguing that the green space ordinance, do you still allow projections and HVAC under 845-48B? Despite the green space ordinance?
What did we-
185-48B.
And what did you say about
Oh,
HVAC?
that's from Jim.
I'm thinking we got it.
There's 48B.
Yeah, I think the answer is yes. Yeah, that's
Yeah.
one we just looked at.
Yeah,
Yeah,
that's
that's this
fine,
one.
yeah.
That's 48B.
Oh, B. It's permitted. That's the open space that,
Right, so,
Yeah,
so this is referring to projections above the ground. This is referring to sills, belt courses, with the exception of chimneys, cornices, and ornamental features may project a distance not more than 24 inches into a required yard.
Correct.
Yeah.
And also
Window,
covers
air.
window and air conditioning units, all right, which cannot exceed 36
no, we've got
inches.
that. No, we agree.
Yeah.
Okay, so those are still allowed.
There are specific exceptions in the code to the yard requirements. And
So this also says air conditioners and heat pump compressors may be located in a required yard.
yes,
Yes.
All right, and the air pumps and heat compressors sit on the ground.
yes.
Okay, good, okay.
With the exception of in a FEMA.
Sure, with
Okay.
the exception of but they can be
Okay.
on the ground. All right, so we are stipulating that and we don't need to go through these, we can spare you the agony in this. So we're gonna stipulate that even though the green space ordinance, the town still allows this. And that'll come together later as we.
Can I interject something? Am I allowed to ask a question?
Absolutely.
Okay. The height limit on the front yard fence is 3.5 feet, is that correct?
Well, that's what we're arguing about.
So
and
put a
that's-
pool there, and the pool safety requirement is 4.5 feet. So to me, you can't have a pool in the front yard? I mean, it's two conflicting things there. That's what I get out of this so far. I'm trying to understand, there's a lot of material
Well,
here.
we're not done, so
Okay.
keep your mind open.
Oh, no, my mind is wide open.
Yeah.
Okay, thank you for the answer, so.
Yeah.
Veronica,
Yes,
can we just clarify, my pool is not in the front required yard, it's in the buildable footprint, it's where I could continue building the house. So it's not confused with, it's not in the setback. Yeah,
so her pool is not. The issue that we were discussing today, and the reason she was denied is because the 4.5, the fence that surrounds the pool is in the front yard setback.
How many feet into the setback does it go?
It is 8 feet.
10 feet from the front
It's
property
Property
line.
line, so it's 8 feet into the setback.
But the entire pool is not in that 18-foot setback. So there's, I guess, tanning area or decking from the edge of the pool to the fence.
So from the edge of the pool that's closest to the street, you're required to have a 3-foot
Right.
walkway.
Right.
Okay, and then she has additional patio, or not patio, but additional area around the pool that's enclosed with the fence.
So the walkway is also in the front yard setback.
That's correct, but the walkway can be grass.
Yeah, the walkway is grass.
So the surface around the pool, at least on that side,
Yes, is grass.
is grass. So, okay, all right,
Yeah.
very good.
And again, I'm sorry, I had trouble reading the surveys that were submitted because they're relatively small and my eyes are bad. So you've got the edge of the pool, and then between the edge of the pool to the fence is how far?
So from the house to the first edge of the pool is 3 feet required. Then the pool is 11 feet, 6 inches. Then I have another 6 inches within the buildable footprint. And so then the fence is 8 feet additional, so 10 feet from the front property line.
Okay.
Which is what the first picture showed, the difference between what it looks like, 10 feet back.
Marcia, do you have anything else that you feel is important you want to add? While she's looking, I think I made this pronouncement, but I just want to make sure that I get it on the record. I would like to confirm for the record that my submissions, exhibits 1 through 9 or 10, whatever I submitted pre-hearing are part of the record. And then we also submitted, both the town and the applicant submitted legal arguments that we'd also like to make part of the record.
Yeah,
I do-
we have your exhibit packet of 1 to 11, and so Fred, unless there's objection, that all comes in. And then this other thing you submitted with 108, 110, and 112 Jersey Street is now exhibit 12. And then we have
These stipulations.
the legal argument that you submitted, and we have the stuff we also got.
And then the final piece is we want the stipulations on the record that we just
Well,
made.
they're on the record,
Yeah.
but I don't know that they're evidence per se, but we agree.
So is there anything else you want to say?
Just one more.
Okay.
Because I think when you're talking about all those things, what we looked at when I looked at the building permits we FOIA'd was really looking at when the green space ordinance went into place in September, I believe, of 2024, and looking at anybody that applied for an encroachment into the front yard setback. So all of those show those encroachments after the green space ordinance. But I think also what's important that I was trying to impress on the town back in January 16th of 2023 6, at the town council meeting, I submitted a report that was very quick, that showed, and I submitted it for the record to the town, that showed 40-plus properties in the north end that appeared to violate 18551A. I did a better survey of that. It was not meant to be precise. It's meant to be eyesight. Are there hedges that are 10 feet high on the property line? Is there a fence over 3.5 feet on the property line? This is not meant to be scientific, but Veronica doesn't have it. I presented it to her. There were 101 over 5 blocks from Chesapeake Street to West Street, all in the NR district. 101 just by sight that appeared by sight of the code we're enforcing on 4.5-foot fences.
May I speak to that?
Sure. Well, you get to cross-examine now, right? You're done your direct
Yeah,
examination?
I'm done my direct, so you can ask Marcia any questions you want.
Well, I don't know that I have a question about that from Ms. Sheriff,
If
but
you want to make a comment about the comment, that's fine, but
I'll get to it later. All right, Ms. Scheck, you said that you were asked to bifurcate or take the pool plan out of your project, and you were disappointed about that, but you didn't say why you were told that the pool plan had to come out of the permit approval. Do you not recall being told that the pool permit couldn't be issued because it was not code compliant?
No, I don't remember, honestly, Mr. Townsend, I don't remember being told anything. The builder called me and told me they've asked me to take the pool out of the plans, which I was objecting to the builder that it's one cohesive plan.
Right.
So I didn't really talk to the town about that.
You had a number of conversations with the town about this subject. I mean,
Of course we did.
but I mean, you testified that there were a couple of conversations that occurred during the course of time when you thought the pool permit would not be issued. Wasn't there any point in time when the town advised you that the pool permit couldn't, like if you wanted to start your house, you could start your
December
house, but you
4th.
were going to have to separate the two different projects?
December 4th
December
is,
4th.
yes, the day after I submitted the pool permit.
December 4th.
I submitted the pool permit on December 3rd, and December 4th, Jim called me and said, I don't think we're going to be able to approve this because of the fence.
But that was that pool permit separate at that time?
Yes.
But so you had already agreed to take it out. So on December the 5th.
I actually didn't agree to take it out. The builder agreed to take it out.
Okay, well.
He did not have my cooperation with that.
But it strikes you accurate that he was told that the house couldn't commence unless you separated the permit process for the house and the pool, because the pool was.
That's not what he conveyed to me.
Okay, all right, well, he's not here. All right, so, back in 2013, you submitted a code compliant, and I say you, I mean, I'm fine saying you.
It's okay.
I'm sorry that you lost your husband, but Mr. Hannewinkle was the record owner.
Yes.
And the two of you had been longtime companions.
Correct.
Right. So, I'm just going to say you, okay?
That's fine.
And I don't think it makes a difference. But you were very much involved you were very much a witness to everything that happened in 2013.
Mm-hmm.
You were aware that a building permit had been submitted to put a pool in the front yard at 114 Chesapeake Street,
Mm-hmm.
right? And that permit was approved. And it was explained somewhat in the transcripts that there was a reason why we had all this difficulty, and it was because the pool was not installed consistently with the permit that was
That's
approved.
correct.
Right. So the pool that went in was larger than the pool that was approved, correct?
the pool that went in was larger than the pool that was initially approved,
Mhm.
and then Bill Mears approved the secondary pool.
Well, that's, Bill Mears, did Bill Mears not testify that he didn't approve the pool? I mean,
Yeah.
I'm not saying he did or he didn't. I'm just saying, didn't he testify during the course of 2013 in that hearing that he didn't give approval?
Actually, Bill Mears testified at the Board of Adjustment hearing that he did give approval, and because I read your arguments, Mr. Townsend, I also brought with me affidavits from that hearing from contractors that were there when Bill Mears came out and gave approval for the secondary pool and the fence in the location 15 feet back.
But you don't have you didn't have a building permit to put the pool and fence in the location or at the height that you did.
That's not accurate. Can I speak to that?
Well, there's no permit that issued on plans that you submitted to build the pool in the location that it ultimately went in.
That's absolutely correct. Can I speak to
Right,
that?
I mean,
Because I can tell you what happened.
well.
It is actually on the record.
But I know, but there's no permit. I mean, the code requires a permit and the code requires a permit for changes and you don't have a permit for changes. So it's still there.
Well, in those days, the town did not require any documentation for changes. Bill Mears generally came out to the site, did a on-site change, and he just said yes or no. And I think all three affidavits I have, including property owners who had the same situation with Bill, said any changes were confirmed by him on the site without any documentation.
Does it surprise you to know that the code says that you can't build in a manner that's not compliant with your building permit?
I did what the building official at that time requested of me, and he did not request. In fact, you'll see in the record that there was a point where he said, "We lost your original permit and your pool plans. Could you submit a new one?" And I asked in the record, "Do you want one with the new pool?" And he said, "It doesn't really matter. We've already approved it."
He's long gone.
Well, he is, but you're also bringing him into testimony.
Yeah. So all right, we'll move on from that. And it's your testimony that in conversations with Bill said that he was under extreme pressure to reverse the decision to grant the permit.
Yes,
That's your testimony.
yes.
And that's why he reversed it.
That's what he showed me.
Although I'm gonna talk to you. I will talk to you about that when it's my turn. Okay, I don't think I have anything more from Ms. Sheck.
Anything on redirect?
No, I think, Marcia, I think you covered it on the 2013.
All right, well, thank you.
I'd like to just call Rich Greenfield very quickly.
Can you state your name for the record?
Yes, Richard Greenfield.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Thank you. Mr. Greenfield, could you please state who you are in relationship to our last witness?
Sure, yes. Thanks, Monica. Everyone, as I just mentioned, I'm Richard Greenfield. I'm Marcia Schick's husband. I've known Marcia now for 6 years. In that 6-year period, I guess back in those days, both of us were widowers. Fairly recent, not recently, probably about 3 years prior to that, both of us had become widowers. So after that time, about 4 years ago, Marcia and I did get married. And we're both very happy that we have that opportunity for both of us to have a second life together of happiness and working together in happiness. So In that 4-year period, I've been working together with Marcia as a partner in the rental business, also working together with her on the builds. We're very copacetic because we're both very honest in what we want to do. We always want to do things the right way. And I feel like that's what I did in my prior industry where I worked. I was a COO in a large organization in Philadelphia, and we wanted to make sure that what we did, I provided services for people with intellectual disabilities and autism, and we made sure that we did everything the right way. According to code, I did a lot of building code up in Philadelphia. I did a lot of Board of Adjustment hearings as well. I did more than that. I did IT, I did insurance work. I did a lot of things with this large organization for 35 years. And I feel like Marcia is very in sync with the way that I like to do business, which is honesty, integrity, and doing things the right way.
So, Rich, are you,
Yeah.
and where do you currently, how long have you lived in Dewey?
And so I've been in Dewey now for 5 years. So I'm a full-time resident in Dewey. Very happily married, obviously, to Marcia, but also happily doing the business that we're working on together for 5 years. So I've been 5 years full-time in Dewey Beach.
And have you been working with Marcia on this project for 101 Carolina?
I have been working together with Marcia on this project, yes.
And were you privy to any of the discussions that Marcia was having with Mr. Dedes and Mr. Zoper?
Yeah, I was involved in all the meetings that we had. So at every meeting that we've had that we talked about back in December and all through January, and also all the phone conversations I was privy to, because obviously Marcia and I were very interested in making sure that this was going to pass through for us and make sure that we can continue forward with the build as it was permitted. And so, yes, I've been involved in all the discussions because it's very important to both of us.
And you heard Marcia's testimony today regarding these discussions?
I heard all those discussions, yes. I was involved in
Did you
all.
hear her testimony regarding what she said happened in those discussions?
Yes, I heard all that, yes.
Okay, so in the interest of time, I'm not going to ask you to repeat everything.
Sure.
I'm going to ask you, did you notice any inaccuracies in the things that she said occurred during those discussions?
No, I did not.
Okay. And did you, you heard her indicate that she had a discussion when the permit was denied with the town manager, who indicated that he was under a lot of political pressure. Were you able to verify that was the discussions with him?
Yes, I can verify that. I heard that on the phone conversation, yes. I can verify that.
I don't have anything further.
Nothing from me.
Thank you.
Ms. Faust, do you have any other witnesses?
So Fred, how do you want to handle Bill and Jim? Are you planning on calling them and you want me to just answer my questions? As long as I can answer any other questions beyond cross, I'm just thinking it's going to be faster if you just call them and then I ask what questions I want to ask.
Okay, that's
Does
fine.
that, does that work? I know everybody wants to get out. I
Well,
mean,
we've been at this for an hour and 45 minutes. Let's take a 5-minute break
Okay.
before Fred starts his case. I think we're all back.
Okay. Back on the record?
Kate's leaving. Are we back live?
You're back.
Okay. Mr. Townsend?
Okay. Thank you. Just a few questions for the town manager to start with. Do you want to sit here?
Yeah, we'll put him here like we did with Ms.
I can
Shack.
go with, oh, you want him up there?
Yeah, I think that's.
Gotcha.
Are you gonna swear?
Oh, I'm sorry, can you say your name for the record?
Carl Zolper?
And you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Mr. Zolper, you said you're the town manager. What is your role here?
So I'm town manager at Dewey Beach. I've been here approximately 5 years. I oversee all the different departments of the town, including police department, building department, lifeguards, parking, maintenance,
You say you've been the town manager for 5 years.
over 5 years.
Okay. And on occasion, are you called upon to be involved in permit approvals and denials and the like?
Usually I'm not, but when I get a request from a citizen to come in and see me and talk about that, which I did in this case, I usually try to accommodate that.
So how did you first learn about this matter?
I think sometime in early December, I think Jim Dedes had told me that Mishek wanted to build a house and put a pool in the front yard at 101 Carolina.
And were you party to any of the conversations that led to the separation of the pool permit from the house permit?
No,
And so that was done prior to your involvement?
yes,
Okay. So you're aware that the permit was in a state of, let's say, denial prior to receiving a letter from Steve Spence on December the 5th?
yes.
Well, what happened after December the 5th?
So after that, I think I received 1 or 2 emails from Mishek asking that she meet with Jim Dedes, myself, and Bill Stevens. Went back and forth a couple different times on dates, and we got a date and a time where we could meet. The mayor wasn't going to meet, but Jim and I decided we thought we should meet with Mishek and her husband.
Okay. And there came a point in time when you decided in consultation with Mr. Dedes that the pool permit should issue, is that right?
So on the 18th, after meeting for about an hour and 20 minutes, maybe an hour and a half with Ms. Scheck and her husband, they discussed the 2013 commissioners hearing where there was a vote of 4 for, 0 against, and 1 abstention for a fence to stay in the front yard at 114 Chesapeake Street. So I'd heard that. I also knew that our current town code was a little gray in certain areas, and Ms. Scheck made sure I understood that. I also looked at the 2013, what I thought was the transcript from that commissioners meeting that was provided to us. I looked at that also. And until that point, I wasn't aware that there was a pool at 114 Chesapeake Street until we actually had that meeting. I was not aware of that. So I went out after that meeting and actually went up to 114 Chesapeake, and there's a row of very large bushes. And then I think behind it's a fence, and probably behind that's the pool. I didn't actually get out of my vehicle and look, but until that point, I wasn't aware of a pool at 114 Chesapeake Street. So I had all those after the meeting, all for consideration.
Okay. You've been here 5 years, so you weren't a party to the events of 2013.
No, I wasn't.
So what you learned about the events of 2013 were what you were told by Ms. Scheck, is that right?
That's correct, and I think by the letter by the attorney Spence.
Okay. Why was the pool permit denied?
So the pool permit was denied when I contacted Ms. Scheck on the 14th because it did not meet the code of 3.5 foot in the front yard. I told her she would have to find relief. I told her I was aware of the community's questions about a pool in the front yard.
What role did the community's interest in this project play in your decision to not allow a permit to issue?
It made me consider it because I had gotten contacted by several folks from the north end that said that they were against the pool in the front yard and the fence in the front yard. So I took that in consideration when I was making that decision.
But is your decision based on the popularity, as Ms. Scheck put it, of the interpretation of the zoning code?
No, it was based on 4.5-foot fence going into the 18-foot setback.
So you saw an email, and I don't know, if we might need some help getting it back up, that was shown from the mayor to you. Could we get that email back up?
That was the minute before.
So that email exchange took place at what time?
So this email with the mayor that I sent was on January 10th at 9:16 in the morning. My call to Ms. Scheck was on January 14th at approximately 8:27. The mayor emailed me on January 14th at 10:30. So I'd already made my call to Ms. Scheck and made my decision. The mayor sent me that email.
So that communication from the mayor, what role did that communicate from the mayor?
I had already made my decision.
Once again, you communicated your decision to Ms. Scheck at what time?
Approximately 8:25 to 8:30. I had a 9 o'clock meeting down on 11 Swede Street. So it was about 8:30, 8:25 when I made the call.
All right. Did a permit on this property ever issue? I mean, a permit for the pool. Did one ever issue?
No, it didn't. Not that I'm aware of, it didn't.
So the permit that was shown on the screen by the applicant or appellant that indicated that it was a permit, that was not a permit issued by Dewey Beach, is that correct?
If you're talking about the one that was shown earlier, I think that was by the county.
So at no point in time had you issued a permit?
That's correct.
And you are not aware of why it was the two permits were bifurcated? Because that took place before you?
That took place before I got involved.
Is there anything else you want to add?
So I want to say my decision on the 22nd of December of 2025 was based on my meeting on the 18th with a lot of information that came in from Ms. Scheck and her husband that came in. It was based on the 2013 decision by the commissioners, which was 4-0 and 1. It was based on a house being at 114 Chesapeake Street with a 4.5-foot fence in the front yard.
Was your decision to allow or to give an indication that you were going to grant a permit on the fence back in December? Was that the 22nd?
The 22nd, yes.
22nd. Had you considered the green space ordinance at that time?
No, I had not.
So the applicability of the green space ordinance was not a consideration of yours?
Didn't come up between myself and Jim Dees or council.
And how about the original state of ordinance 14 and section 8.4? Where I can represent to you that the standards that the applicant is relying on included a word that no longer, that didn't appear in the code back in 2013.
So is that, you're referring to rear?
Mm-hmm.
Yeah, I was aware of that, and but it wasn't in the code.
But you weren't aware of, you didn't become aware of that circumstance until after you had indicated that the pool permit might issue.
Yes,
correct. You came to know that later on.
yes, correct.
Did that play a role in your decision?
On the 14th of January?
Well, never mind, you don't need to answer that. That's all I've got for the town manager.
Ms. Faust?
Bear with me one second, please. Yes, so Mr. Zolper, when you called Ms. Scheck on the 14th to let her know that she was approved, and you did at least tell her verbally that she was approved, did you agree to that?
On the 14th or on the 22nd?
It was December 22nd.
The 22nd, I called her.
December 22nd, so you do agree?
Yes.
You told her verbally that she was accepted.
I did.
And did you also tell her at that time that you had consulted with attorneys about this before telling her she was accepted?
I told her I talked to counsel.
Nothing further. Thank you so much, Mr. Schultz.
Anything else?
Fred, anything?
I mean, I don't know,
Thank you.
I don't know if there are any questions that. No. No.
Yeah, well, I wasn't exactly sure the protocol, if we were supposed to ask questions an hour later, so just letting you put on your cases and then.
Okay, so can we hear from Mr. Dedes now?
Certainly. Can you state your name for the record, please?
Jim Dedes, James officially, but Jim I go by.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Johnson.
Mr. Dedes, what's your position with the town,
I'm the assistant town manager.
assistant town manager? Could you
And-
pull the microphone a little bit more?
I'm the assistant town manager, and I'm also the building official right now.
You're the acting building
Acting
official?
building official,
Is
yeah.
that's pursuant to a
To
document?
the resignation of our other official town, building official, Dawn Hanks.
So we don't have a town official now, is that your testimony? I mean, excuse me, we don't have a building official per se right now.
Right now, and I'm filling the position.
How long have you been with the town?
Since I believe 2012. Officially 2005, I've been involved. Actually, 2006, I was appointed by the town, one of our town, not the town manager, but actually the mayor, to serve on the Planning and Zoning Commission. And I did that for 10 years.
But you served in this role for how long?
Well, 2012.
2012, okay, thank you. So how did you come to be aware of the building permit process or building permit application at 101 Carolina?
You mean in this particular one,
Yes.
or just in general?
This one.
Okay, may I call Marcia, please? Makes it a lot easier. Thank you.
Yes.
Marcia applied for a building permit on 101 Carolina Avenue. And the original building permit included a house to be built by Evergreen Homes and included a pool all on the same property.
And subsequently, those permit applications were split into two, is that?
There was a lot of discussion. Marcia and I had talked about it, and she wasn't excited about my recommendation. I talked to Evergreen Homes as well, and I said, we have a choice here. I said, I can deny this permit because I don't think the fence meets the town requirements, and it's gonna hold up your house because it's all tied together. I recommend that you might consider separating the two. And I mentioned it to Marcia, and I did bring it up with Evergreen Homes. And I spoke to I guess it's the salesperson, and I believe, I'm not sure his exact title, but he seemed to be the one that processed all the paperwork and coordinated the applications.
But you did have a communication with Ms. Scheck
Oh,
about,
absolutely, several times.
and she was desirous of getting the house started, right?
Absolutely, and my thought behind the process was, I think that the most important part was get your house built. And if this goes into where we are today, at least your house is built. And I think that's how we came up, at least they came up, that this makes sense. They didn't like it, but they followed my recommendation.
Okay. Was your recommendation based on a conclusion you reached about the compliance of the pool project?
Yes.
And what was that?
That the pool was outside of the required setback, but the fence was 4.5 feet, did not comply with the 3.5 foot permission to have a fence in the front yard setback.
So there are, you read the town's submission, right? There are factual representations that I made, or that were made in that submission, is that right? Do you want to correct any of those, or?
No.
They're accurate to your knowledge?
Yes.
The pool itself is not located in the front yard setback, correct? We heard testimony to that effect.
Yes.
So what's the problem then with the fence?
The fence goes into the setback. You have a pool and a surrounding area of a 3-foot perimeter that goes out. That is inside. That is not in the setback. The problem was the fence was set into the town setback. And, you know, my interpretation of the code is you cannot have a 4.5 foot fence in the town setback, only a 3.5 foot fence.
Were you, did you feel at any point that did you play a role in the decision-making that resulted in the indication in January that the pool permit wouldn't be issued?
Yes.
Were you free to exercise your judgment in that case?
Absolutely.
Did you feel like you were under pressure?
No, Bill and I consult, and we consult. If we disagree, we disagree, but we usually agree to everything. So we were in concert.
But you weren't, were you ordered by
No.
anyone, the council or anyone to either grant or deny this permit?
No, I was not.
Did a permit ever issue?
No, only a referral to the county.
So you understand Ms. Scheck's point that it seems like once you get as far as the county that the permit is probably going to issue, and you heard her testimony that
Yes, I
oftentimes
did.
it does?
I would say she's correct for the most part, that I'm not aware of any time we've sent a referral over and denied a permit. What I am aware of, I have stopped work on a permit that we issued for failure to meet zoning requirements. They didn't follow the plans as that, so it's usually after the permit has been issued.
And you stand by the decision that was made to withhold the permit?
I do, I don't see, I mean, I read the 2013, I have to say, I was swayed, but having consulted with council, is my understanding that is a one-off, that it didn't go forward because it was not I guess the Board of Adjustment makes decisions only on that one issue that comes in, doesn't set a standard for everything. And I didn't think that it set a standard for everything.
Have you granted a permit for a 4.5 foot fence in a front yard setback?
Not for new fence. I've granted repairs. We allow that to go in, and I have granted for a repair of an existing fence.
So was that the legal non-conforming?
That's on legal non-conforming homes.
Have you had occasion to grant a permit for a pool to go into into the area, into the buildable area in front of a house recently? Or ever?
You mean in the front of the house?
Aside from 114 Chesapeake?
I've allowed 3-foot fences, yes.
No, I'm asking about a pool.
Oh, a pool?
Isn't there another property on Carolina Street where there's,
Yes, thank you. 11 Carolina, we did grant that. That was done not by me initially, it was done by a predecessor, but there was concern that they did have a fence coming in, and I wasn't clear on the fence. And I contacted the company, it was Forest Fence Company, and we said, unless we get clarity, you're not issuing a fence. They did provide the clarity. I actually went out with the survey markers were still on the property. And I saw exactly where they were putting the fence, and it was a 7-foot fence, which is permissible, but it was within the buildable lot. It did not encroach in the 18-foot setback in the NR district.
okay, so that 7-foot fence satisfies the requirement
It did,
for a
yes.
pool safety fence, correct?
More than enough, yes.
Is that the image there of the property we're talking about?
That is correct.
So you can represent that fence, there's a good view of it.
On the side,
You can represent that fence is not in the front yard setback, correct?
correct.
What kind of a fence is that?
It looks like it's a custom-built fence. It's a wood fence that was put up by Forest Fence.
Would you say it's a privacy fence, or it acts as a privacy fence?
I would say it acts as a privacy fence, and it meets the conditions of having a safety fence around the pool.
If you granted the permit to Ms. Scheck to install the pool fence that she showed us an image of, would she be required to use a metal fence construction?
No, we
One that would
no
allow
fence.
light to go through?
I'm sorry.
One that would allow light to go through. Can a pool safety fence be a stockade fence?
Yes, it can be an aluminum fence.
It can be an aluminum fence like she showed, but could it also be a fence like this one?
Yes,
And if you granted the applicant's permit to install that fence, could they install a fence like this instead?
sure.
They could if they
Yes.
asked, I mean, you couldn't deny it, right?
No.
And if you accepted the applicant's position that a pool safety fence is exempt from the front yard setback restrictions, then how far forward could that fence go?
If they're exempt, they could right to the front of the property line.
So that fence
Could be
there,
brought up right to the, if that happens to be on the south side, it could take it to the south side of the property line.
so can you give us roughly an idea where that would
So
be?
my apologies, Fred, I'm not understanding the question. Can you repeat that? I'm sorry.
If the code was interpreted as you proposed it be interpreted, that a pool safety fence can go in the front yard setback area,
That is correct.
then wouldn't this fence be permitted to extend forward all the way to approximately where that white stake is, or?
I would say that because of the angle that it's at, I would say probably to the right of that is where it looks like it's a light pole. But there was another picture prior to this which showed you the front of it. And you see that, you see where that cone is? Right behind that cone is the property line.
So
You see that, and that's where it could
the
go.
pool safety fences then are not restricted in the front yard, then that fence could come forward all the way to the property line, correct?
That's correct.
And that fence could look just like that one. How about a concrete wall? Could that be installed?
Concrete wall could be installed.
I get
It
it.
it allows for stone, and we would say that the concrete wall probably could be allowed. The only thing we don't allow is chain link fences or wire fences.
So that's what the code says, right?
Correct.
So, this one, sorry. I think it's the first slide. So do you recognize this?
I do.
What is it?
This shows in the NR district, and it was used by the planning commission to give some examples of what the lot coverage could be.
Push
And-
the mic over a little.
Yeah,
And the dimensions basically
trying
are
to get-
50 by 100. And that would be in the front yard, the lot front. What you see is the checkered area, that would be the buildable footprint. And the setbacks in the NR district are 18 in the front, 12 in the rear, and 8 on both sides. And it's a little different on corner lots. And Marcia has a corner lot, it's a 12-foot side setback on the east side of the property.
whatever it is, this is a definition of the word yard that appears in our code, is that right?
That's correct.
So, what can you, so in the NR district, the front yard is a reference to what?
The front yard is basically in reference from where the house sits typically. And,
Well, that's not what this says.
No.
This says that the front yard is defined as the restricted area
right,
on a lot, correct?
correct.
And that's, in the NR district, that's 18 feet, right?
That's correct.
Doesn't have anything to do with the house, actually.
No.
So, if you used this diagram to describe that other house on Carolina that we just looked at, that tall fence is located where on that diagram?
Well, it would be easier to point right here. If
No,
it was
that's-
allowed.
that's-
If it was allowed, this is the buildable lot.
Okay.
Right over here.
No, but I'm saying the one that is there,
On 11 Carolina.
that you permitted, that fence is where on this lot, this diagram? Okay, running all the way across,
All the way
right?
across.
Okay.
Well, it's got a driveway on the other side.
So the buildable area is defined how in this diagram?
By the checkered lines.
So what's within the checkered line is the buildable area?
Yes.
Is that right?
That's correct.
And that's where the house goes and other improvements, is that right? So what some people might think of as the front yard is not always the front yard by our code, is that right? Can you explain that?
Yes. The front yard, a lot of people see the front yard as anywhere, like I said earlier, like where the house is all the way across. That may not determine the exact front yard. The front yard that we look at it is really the 18-foot setback area.
Okay, so there was some question about whether a fence is permitted in the required front yard. So a certain fence, a fence of a particular height is permitted in the required front
correct.
yard, is that right?
That's correct.
What are the fence height requirements in the other yards?
When
Or
you say
fence height maximums in the other yards?
in the frontage, the front yard set?
No, in the side yard and the rear yard.
Oh, okay, 7 feet on both sides and 7 feet on the rear.
All right. There are other exceptions that were brought to your attention in the code. There were a couple of code provisions that Ms. Faust brought to your attention, and they allow for projections into the code in some instances, or
Yes.
into the setback in some instances, is
Yes.
that right? Is that because the setback is supposed to be open to the sky?
The setbacks are supposed, yes,
And then, how about HVAC equipment? That's not a projection
that's
from
not a
above.
projection, it's on the ground, typically it's on the ground, and we allow for them to go into the setback, I believe it's 3 feet.
And that's a code provision
That is a code
that you
provision.
rely on.
Right.
Okay. To your knowledge, when the decision to permit, well, is it the case that sometime in December, before receiving this December 5 letter from Mr. Spence, that you had indicated you would not be approving the pool fence?
Correct.
Is that why you got a letter? Is that why you got an expensive letter?
You got that right.
You wouldn't have gotten one
No.
like that in support of a permit request if it wasn't
Right.
refused, right? After that, there was a decision to allow the fence permit process to continue, is that right?
That is correct.
And there was an indication to be favorable to the applicant that it would be issued, correct?
That's correct.
But it was never issued, right?
Oh,
Did you consider during the point in time when you went from a posture on the permit that it was not approved to when it might be approved or would be approved, had you considered the green space ordinance in your thinking?
no, not at that time, no.
That's all I have for Mr. Dees.
Just a couple quick
Yeah,
questions.
Ms. Faust.
Mr. Dedes, a 3.5 fence, is it allowed to go all the way to the property line under the code?
Yes,
Okay. So you could take it all the way to basically your street line?
yes.
Okay.
Well, to the front of the property.
Correct.
The 18 foot, yes.
All right, and you talked about that you had never revoked a permit, or I'm sorry, never not issued a permit after you got the county permit, except for in certain circumstances when there was a violation of the code.
Right.
And those, was it a violation that you determined after the fact, or because they
It
weren't?
was after the
compli-
fact.
Okay, a violation that was
Yes, it
determined
was.
after the fact. And can you give me how many times have you done that?
Several times.
Okay.
We've issued stop work orders. It's not, I mean, we try not to, but this was so flagrant, the one I was
So is
talking
it
about.
because they weren't complying with the plans that they submitted?
Correct.
All right, so it wasn't that the plans that you changed your mind on the plans that they submitted, but they weren't complying with the plans that they
That's
submitted?
correct.
Okay. So if Marcia's would have issued pursuant to the verbal, you wouldn't have retracted as long as she did, as long as she built it in accordance with the plan she submitted to you?
Yeah.
That's all I have, thank you.
Anything on redirect, Fred?
No, sir.
Okay, thank you, Mr. Dedes.
Thank you.
Mr. Townsend?
Can we hear
any other witness?
very briefly from Kate Banaszak, please?
Would you state your name for the record, please?
Kate Banaszak.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Ms. Banaszak, what is your role here with the town? What office do you hold?
Town clerk.
And for how long have you been the town clerk?
Clerk for about 3-4 years.
What does that office require of you? What do you do as the town clerk?
Record keeping, taking minutes, do a lot of other things, but those were the main duties.
Projects
Yes.
on occasion?
Yes,
Are you our virtual IT specialist as well?
yes,
You are also the FOIA coordinator, is that right?
yes,
Maybe other things. Do you on occasion get called upon to draft ordinances?
yes,
How about doing research on prior legislative, state of the law, things like that?
often, yes.
Did you, was there a point in time when you were either called upon or came to the conclusion that some research on the provision that's in question here, 18551B, would be wise to do?
Yes, that was at the January town meeting, January of this year.
So, what is it that you did? Or first of all, why did you feel, or I can't remember if you were told, or why did you feel it might be helpful if you did some legislative research regarding that section?
During that meeting in January, Commissioner Persinger brought up a concern with the verbiage provided in 18551B. Believe if I summarize it, was something to the effect of accessory swimming pools may occupy a required yard or side yard. He stated on the record that he thought that verbiage was odd. Why say required yard or side yard? Why not just say yard? We knew this was going to be an ongoing discussion. So because of that, I decided to do some research after the fact to find out why maybe it was written that way.
And what research did you do?
I looked through our past ordinances, found that ordinance 14, which I think was approved in 1982, was the first mention or the first draft of that section of the code. And at that,
It was actually the full zoning code at that time, right?
yes, we didn't really have a zoning code. It was a bunch of ordinances and nothing was codified into the zoning code. That wasn't done until years later. But at that time, I read that ordinance and the verbiage was different. It stated a required rear yard or side yard.
So is there an extra copy of my exhibits here? Could you take a look at, I think it's Exhibit 5. And I know they're not tabbed, but if you flip through them. Is this what you found?
Yes,
So is this an excerpt from Ordinance 14?
correct.
What tab are we at, Fred, please?
It's Exhibit 5. So you said that Ordinance 14 was adopted in 1982, you thought?
Yes,
Is this part of it?
yes.
Do you recognize the language in 8.4?
Yes,
Can you compare that language to the language that was in our code until we amended it recently?
yes, the word rear was not in our code.
So you recited from memory that language without looking at it, but were there any other differences between the language at 8.4 and the prior iteration of section 151B?
If I recall correctly, they took out the mention of chain link, but that was it. Everything else was the same. You're comparing this to our current code.
Yeah, so our current code does have that. I mean, if I represent to you that chain link language is in here verbatim, what I can do is, let's go to ordinance 80, let's go to Exhibit 6, the next one. Oh, okay. Maybe chain link is not there. Oh, I know where it is. Does this language illustrate the current state of the law?
This,
And the language I'm referring to is in section 2B. Was this
Just what
adopted?
language, Fred? Can you clarify?
Was this
that?
adopted? This
you're
word?
looking at ordinance 875 now?
87526, yes.
Yes,
Section 2, subsection, or B there.
yes,
Is that the language that is currently the state of the law in Dewey Beach?
yes.
And what's the difference between that and what existed before this was adopted? The word rear? Is that what did this code provision do?
It put the word rear back into section 2, or, yeah.
So what did you do in the way of research? How is it that you have any degree of confidence that, that 18551 wasn't amended after 1982 on purpose to remove that word?
I looked through all of our ordinances after ordinance 14 to find out where or why the word rear would have been removed. I came upon ordinance, I'm not going to remember the number of it now, but it was approved in 2009. What that ordinance did was take all of the previously adopted zoning ordinances and put them all into a zoning code. That was a long process from what I could tell, looking at a lot of minutes. I could find nothing leading up to that meeting in 2009 that stated the word rear meant to be removed. It just was missing when all of those ordinances were transcribed into a code. The word rear was just gone.
Before this ordinance you're talking about that codified the code, there was what? Just a series of ordinances that related to zoning?
Correct.
So were they then given new section numbers and reorganized in the form of a book?
Yes,
Okay, how about minutes? Did you look for any minutes or anything that could explain?
I did.
Did you find anything?
No.
Did you spend 5 minutes on this project? Or
No.
what did-
We do have a digital archive that I can text search, so I used numerous terms, went back through, I would say, everything was codified by that ordinance in 2009. I believe I went back to around 2005 or 6 and started there looking for any minutes in the lead-up discussion to that approval in 2009 to see if there was any mention of we want to remove this word, and I could find nothing.
If I told you the ordinance that codified the zoning code was ordinance 634,
Sounds right.
does that sound right? Okay, and that was in, you said 2009?
2009?
Okay. Do you communicate with the codifier who publishes that book online for us?
As needed, yeah.
Yeah, is that a role that, I mean, what happens to ordinances that get adopted? Who's responsible for getting them to the codifier?
That is me.
That's
So, yeah, as ordinances are approved, it's my job to make any amendments, get those signed off by our town manager and our mayor. After everything is done, they are sent to our codifier. At that point, they kind of hang out in a new laws section and wait to be formally put into the code. We do that about once a year.
That's all I have. Ms. Madison.
Hi, Kate.
Hi.
Question for you. You say you have you searched your digital archive. And so the ordinance, and excuse me, Fred, can you give us the number of the 1983 ordinance? We don't have the whole ordinance, we just have, you just gave us a page.
Ordinance
it, but-
14.
But it's 14.
All right, so ordinance 14, in the materials, we've only given one page of the ordinance, but that was adopted in, you're testifying that was adopted in 1983.
82, I think it was.
All right, so it's got a date on the bottom, 2/18/83, what does that mean?
I'm not sure. I just am going off the date that it was signed, which is on the last page, and that had 1982.
Okay, all right, and you said, how far do your digital archives go back?
From the inception of the town, we go back to ordinance number 1.
Okay, so and basically, when you're searching these ordinances, you're telling me you're doing a text search.
Yes,
So it's like doing a Google search.
I suppose, sure.
Yeah, so you gotta have exactly the right words, right?
Sure.
Did you check, like, how did you check the minutes? And, I mean, do you have minutes from every meeting from 1983 to the present?
As to best of my knowledge, yes. I couldn't vouch for that since I wasn't here in 1981 when that process
Were you
started,
born
but we,
then?
I was not. But I know that we do have minutes dating back to 1981, 82, and so on. Those are scanned into that archive, I should
So they're
say.
scanned, they're
Yes.
scanned into the archive. All right, so, so I want to bring, I want to ask you, you had indicated, and we're going to bring up our exhibit number 1, that is the 2009 ordinance.
Okay.
Does Kate need to?
Do you need me to run to the back and put your PowerPoint?
Oh, no, it's, we just have it in the packet.
Yeah, but
I don't know if the-
they may
if
not
the-
have that in front of them.
Yeah, they may
because of
not
the
have
number
it in
of
front of them.
pages.
I'm sorry, can we get this?
Yeah.
2009. Exhibit 1. A.
This one?
Yeah.
Yeah, that was a couple of these.
So it's ordinance 634. Sorry, guys,
634, 54.
634. Can I make a recommendation? Did you guys get a remote that you can actually get to the actual exhibit that you want?
I would love it, yes.
And I can't see the,
It's Exhibit 1, 634.
But in the big one,
This
there's
should have been
300
our exhibit
pages that
one.
they submitted.
Yeah, the very first.
We didn't print this off.
So it's not this exhibit 1.
Here, I've got it here in mine.
All right,
There they go.
you have a copy of it?
I see it.
Yeah.
Here it is. Okay.
Okay, you there? Okay. All right, so Kate, so as the town clerk, you can verify that this is in fact an ordinance adopted by the town in 2009, correct?
Correct.
All right. And it was actually, this was not a situation where you just sent a newly adopted code or a newly adopted ordinance to the codifiers and they added it to the code, right? So typically, don't you get a new ordinance adopted, and once that ordinance is adopted, you send it over to your code people and they add it to the code, correct?
Correct.
All right, so in this particular, in 2009, what happened is the council adopted a whole new zoning ordinance, isn't that correct? And that's what this ordinance 634 does,
Correct.
correct? All right. So, I want you, I'm going to ask you to read from ordinance 634. In particular, I would like you to read, starting with now therefore.
Now therefore be it enacted and ordained by the Commissioners of the Town of Dewey Beach, Sussex County, Delaware, in session met as follows. Section 1, Chapter 185 zoning of the Municipal Code of Dewey Beach, Delaware, 2005 as amended is hereby further amended by deleting Chapter 185 in its entirety and inserting in lieu thereof new Chapter 185 attached as Exhibit A. Keep going.
Yep.
Section 2, the Commissioners of Dewey Beach adopt the findings of fact dated January 10th, 2009, attached as Exhibit B. Section 3, if any provision of this ordinance shall be deemed or held to be invalid or unenforceable for any reason whatsoever, then such invalidity or unenforceability shall not affect any other provision of this ordinance, which may be given effect without such invalid or unenforceable provision, and to this end, the provisions of this ordinance are hereby declared to be severable. Section 4, this ordinance shall, good, okay.
Thank you very much. So is it fair to say that the council adopted the entire code that was attached as Exhibit A?
Yes,
And they came together with finding of facts and adopting that code?
yes,
and the ordinance was executed, was voted on and signed on the January 10th of 2009 per the ordinance, correct?
Yes,
And it's signed by the mayor and the town manager?
yes.
So I want to draw your attention to 185, 51, and I'm extracting a page from exactly Exhibit A to the ordinance. So Christina, can you bring 185? So this is Exhibit A to the 634 that was adopted in 2009. So I want to bring your attention to 18551B. And is the word, you indicated that in the 1983 ordinance, the word "a occupy a required rear or side yard."
Rear
and
yard or
rear
side yard.
is missing from this
Correct.
code provision, right?
Correct.
And is it correct that the 1983 version also said that a protective fence had to be 4 feet?
At least 4 feet, yes.
Okay.
Mhm.
And then how high does a protective fence have to be under 185D?
At least 4.5 feet.
Okay, so in addition to, it also, this ordinance also changed the fence height.
Unless it was done in between those two ordinances, which I couldn't say for sure.
Okay, so you couldn't find anything in the records that did that? But it could have been found, it could have been changed in
It could have
between.
been, but I'm not sure.
Okay, and rear could have been omitted in some other ordinance just as easily, correct?
Not to my knowledge. Since that's what I was looking for specifically, no.
Okay, but you didn't look to see if there was a 4-foot change? in
I
the
did
fence?
not, no.
Okay. And how did you do that search? What was your search parameters if you didn't pick up this change in the 4.5 from 4? I'm just curious.
Well, I searched through the ordinances one by one, just to look at what was approved between ordinance 14 and 6, whatever it was in 2009. Those I looked through one at a time, just to see what was approved and what was not. Where it got a little more dicey was looking at the minutes, looking for a specific mention of someone who intended to remove the word rear from that section of the code.
Thank you, Kate.
Just real quick, I think you answered this, but you weren't looking for an explanation for why that reads 4.5 in our current code.
No.
I mean, you could have possibly found something.
Sure.
But you weren't looking.
I wasn't focused on that, no.
You were focused on
The word rear.
the word rear.
Yes.
And do codes get changed by minutes?
No,
So do you have you say you have copies of all the ordinances that were adopted?
yes.
Was there any mention in these, did you look at these findings of fact that were part of ordinance 634? I mean, is there any mention in there, in those findings of fact, that we need to remove the word rear so we can get pools in the front yard?
No. There was no mention of removing it at all.
All right, that's all I have.
I just one more question. There's no mention in the finding of fact about changing anything in the code, is there?
Okay.
Can we at least stipulate to that?
I'm not sure. I mean,
Well, you asked her in the findings.
you showed a list of findings of fact, and if there was a finding of fact that said the code should be changed in a particular way for a particular reason, then I think that would be relevant.
Well, I'll just say for the record, I don't think that's a fair characterization because the findings of fact talk about imply there are changes. The zoning regulations and zoning districts anticipated under the proposed ordinance are generally consistent. So I think fairly reading those statement of facts, it's clear they were making changes when they adopted the new code. They don't specifically say, these are the changes we're making, they just adopt the new code. But I don't think it's fair to say that this recodification didn't include any changes, because why else would it?
That's the point I'm making.
Yeah, that's fine, I'm fine.
That's the point I'm making.
Okay. Thank you.
Yeah, thanks.
Mr. Townsend, do you have any
I
other
have no further
witnesses?
witnesses.
All right. So, you've heard the witnesses, now we're gonna have, I'll say, the legal argument portion, move on in the show. But before we do that, I want you guys to be really focused. And I don't wanna have like a 20-minute soliloquy. But I have a couple questions that I want you to consider. So what I'd like to do is, I'm gonna read my questions, because they're the questions that certainly will inform my discussion with the board after you guys make your argument. And certainly, board members, when they're making an argument, you also are free to ask questions. I don't want to suggest you can't. But I think I've got the one question I had. So the error in the code codification, to the extent it was an error and wasn't intended, that wasn't discovered until sometime after January of 26, based on the testimony we just heard.
Right.
But here are my questions. Don't answer them during your argument. I don't want you to answer them now. I just want you to think about these. So we had a new ordinance that was just adopted in March, 875-2026.
It was this month, I think. Was it April? There might have been testimony that it was March. Was it April? April.
Okay, sorry.
No, that's not the distinction.
So,
of that.
but the point is, it has just recently been adopted, this new ordinance. And so my first question is, would you agree that if, and I'm emphasizing the word if, that ordinance that was just adopted applies, then the pool and the fence at issue here would clearly be prohibited, because I think, as I read that ordinance, you absolutely could not have a fence more than 3.5 feet in the required setback. So if it applies, would it prohibit the fence that's at issue here? My second question, if we know, nobody has said, is when was that ordinance actually introduced? I presume it was introduced sometime after the application was made here. And then my third question is, does the ordinance apply? Should it apply? Because it seems to me you're arguing about an ambiguity that existed, past tense, in the code that has now been removed as a result of this new ordinance. And so one of the interesting things whenever this happens, and land use can be a very unfair process, don't get me wrong, I'm a big believer in property rights, but does this ordinance that was just adopted apply to this situation or not? So think about those things when you're making your legal argument. Oh, nobody has said it, but I'm just curious. Has construction on the house actually started?
Yeah, it was said, and it's halfway
Okay, well, I
done.
missed it before
Halfway
you said, and I
done.
apologize. Now, if we're just looking at the original ordinance and we assume that the new ordinance does not apply, then my first question would be, how could I have a pool in the required yard without also having a 4.5-foot fence around that pool? In other words, if the code as written before the amendment does permit a pool in the required yard, doesn't that imply that you also get the fence? Otherwise, you can't have the pool because you can't have the fence and the code would be meaningless. Now, that's if I read the code as saying that a pool is permitted in the required yard. But the other thing, the other question then, and then I'll let you guys, maybe we can take a 5-minute break after this, is, let me find it here. Oh. So the code says, again, before it was amended, said accessory swimming pools, open and unenclosed, may occupy a required yard or side yard, provided they are located not closer than 10 feet to an interior side lot line or 6 feet to a rear lot line. Now, ordinarily, when you're drafting a statute, you don't include surplusage, right? You don't include words that are duplicative and otherwise serve no meaning. So, on the one hand, we could read a required yard to mean the front, the side, the rear, any yard. But it says a required yard or side yard, and then it says you can't be any closer than 10 feet to a side lot line or 6 feet to a rear lot line. So if I'm going to assume or try to interpret that statute as meaning a required yard includes a front yard, I note that there's no setback from the front lot line.
Right.
And so does that mean I could build a pool? I would guess it could be no closer than 3 feet from the front lot line because there's no requirement. Or does it mean that what has been suggested when this was recodified, that when they said a required yard or side yard, what they meant to say was a required rear yard or side yard because they list 10 feet and 6 feet with respect to setbacks from the side lot line or 6 feet from a rear lot line. So we're here, I mean, in 2013, the building license, I was here in this room, so was Ms. Scheck. And the commissioners voted to not have the building license revoked because in their view at that time, they thought the code was ambiguous. It's been amended at least twice with the green space ordinance and this most recent ordinance that was just adopted, I thought March, but April, this recent one. Does that change anything? And so with that, can we take a 5-minute break and then we'll hear the argument from council? Sure.
Okay. Okay, so we're ready for our closing arguments.
Okay. I'm feeling a lot of pressure here because we're so late. And I've got,
I will tell you, just before you get started, I've been talking with committee members because it is late. Our plan is to let you all do your closing arguments. We're gonna keep the public hearing open. We're gonna continue it to a date, we're looking at about probably maybe in 2 weeks, to continue the meeting. And then at that time, hear the public comments. If anybody there's nobody here in live, but I know there are people that are online. If they can't attend whatever date we decide on, they can submit any comments they have via email to the town. And then we will make a decision at that time. This is a lot of information to digest. Here we are, we're 3 hours in at 9:30 at night. I don't want to rush anybody's decision. I think this is an important decision to make. And obviously, this is actually a two-part hearing, because we've got the appeal, and then potentially, depending on what happens with the appeal, we've got the variance request. So that is my plan to do that. And I just want to let all the parties know that's kind of where we're headed. So make your arguments, but we're not, that's where we are.
no, I understood, and we appreciate it, and we're sorry that it took so long.
No, and I understand.
This is a very complicated
It is
case.
complicated.
It's very complicated.
And that's why.
It's hard for the lawyers.
And that's why, and I'm a lawyer, and it's complicated for me too. But the board members just feel that's the responsible way to approach this, so that we can make sure we've digested all this information and we can move forward responsibly. So that is the game plan. And like I said, after you guys are done, we're gonna get on our calendars and figure out roughly maybe 2 weeks out. So it's not too far, so that we don't forget everything. And make sure that everybody in this room is available as well. That is our plan. Does that seem acceptable to everybody? Okay, so, go ahead.
So, thank you. Again, we are here for the appeal of the denial of the building permit, the pool permit for Ms. Scheck at 101 Carolina. Most of this is in my submission. I'm going to try to condense this. You guys are acting in a quasi-judicial capacity, so you were the judge and jury here for us today. I just want to start with some of Mr. Forson's questions. He asked if the ordinances that was adopted in April of this year, whether that precludes, our appeal and and trumps the ordinance that we were operating under, and we definitively can say no. Under the pending ordinance doctrine, she made her application well in advance of the ordinance that was under consideration, and under any of the prongs for a pending ordinance under the case of Covington versus Board of Adjustment, at 2016 Westlaw 7242581. Her appeal is not barred by the pending ordinance doctrine. So that's the one thing I want to address. I'm going to be answering the other questions Mr. Forson asked in the course of my discussions here. But I want to talk about basically the town denied again Mrs. Scheck's pool permit on the basis that it did not comply with 18551A and 18592A2. Right, so 18551A is the ordinance that says, hey, you can have a fence up to 3.5 feet in your front yard setback. And they also based it on 18592A, which is the ordinance that, basically, you want to bring that up? Yeah, it's 18592A is up there. It says ornamental fences or walls may project into an enclosed yard, and you can read that statute. But I think it's imperative when you are evaluating this that you do read the strict language of the statute. So the first argument we've made, and I think Mr. Forston acknowledged it, is that if a pool is allowed in the front yard setback, okay, and Mr. Dedes explained what a front yard setback is. If a pool is allowed in the front yard setback under 185-51B, then a fence must also be allowed in the setback because 185-51B requires a fence, okay? So it necessarily follows that if the pool is allowed, the fence is allowed. Now, the town disputes whether a pool is allowed, and we're going to get to that in a minute, okay? The next thing that we want to address is that, and I'm only talking about 185-51. So can you pull up 185-51A and B? So we have 185-51A and B here, and one of the things the board needs to consider when they're addressing this is statutory construction and the idea that under the terms of statutory construction, the specific overrides the general. And it's our position that when you read this ordinance, it's very clear that they're establishing a wall, a hedge, fence, or wall that's not more than 3.5 feet. And they're also establishing another accessory use because this statute is establishing what accessory buildings and structures you can have in the town of Dewey Beach. Okay? So we're saying that it's clear from a read of this that they're establishing a fence or wall that's 3.5 feet, and there's also a fence that you can have a safety fence around a pool. And if you can have a pool in the front yard, as 85-51B says, then you must be able to have the fence. I want to also give some context because, 81-51B talks about a swimming pool that is a protective or safety fence. All right, 81-51A just talks about a general fence, okay, a hedge, fence, or wall. And it also says that fence can be 3.5 feet in height. I want to bring your attention to design guidelines, which is the 185-92A2. This is in the design guidelines section of the code. Under the design guidelines, and this is where, your building and the town tells you, okay, these are some design requirements when you're building. It says ornamental fences or wall may project into a closed yard provided no fence shall exceed 7 feet in height, or if you're in the front yard, you can't be 3.5 feet. But 1 and 2, although they say new fence, what they are under is ornamental fences. So 185-92 clearly applies by its plain language to ornamental fences. Interestingly, 185-92 says ornamental fences can only be 3.5 feet in height. That's the very same language that is used in 185-51A. So 185-51A, if you read the code together, was intended to cover ornamental fences, like hedges, walls. It's not intended to cover safety fences or barrier fences for a pool. The other thing that I want to note is that if you look at, and I don't want to go through it all now because it's going to take too long, but I want you to go to Article 8, which is in the supplementary zoning code. You want to pull that up, Christina? So Article 8, supplementing height and bulk regulations, 185-51A and 185-51B, and you'll need to see this in context, which is why I want to have her bring this up. Okay, there we go. So can you raise it to 185-51A and B? All right, so what you can see is this section, Article 8, is the supplementary height and bulk regulations for the town, all right? And and the accessory structures, or accessory buildings and structures is contained within it. And the thing I want to point out is that when you look at 185-51, if you look at A, B, D, and E of that code, it tells you 4 types of accessory structures that are permitted in the town. Okay, so A, B, D, and E. And then C, F, and G tell you, hey, we're allowing these accessory structures, but these other things aren't allowed. Okay, so what I'm pointing out about 185-51 is if it's telling you something's not allowed, the statute, whoever drafted this knew how to tell you something wasn't allowed. Because they clearly told you that in C, F, and G. These things aren't allowed. So they could have said, safety fences aren't allowed in front yard, but they didn't. So I want to bring that up. And then again, the town said that 185-92 was a reason that this 4.5-foot safety fence could not be in the front yard. And again, our position is that statute clearly, or that ordinance clearly applies to ornamental fences only. So the next argument I want to get to, and I've reserved rebuttal, and I'm going to rebut some of Fred's comments after he goes, but I do want to address a couple of things. I don't know if you've had the opportunity to review Fred's, the town's, Fred. Fred, Veronica, the town solicitor's arguments regarding, our preliminary legal arguments. What the town seems to argue is that despite the fact that 185-51B says accessory swimming pools can be in the front yard, that when the town adopted its green space ordinance, ordinance number 843 and 920 of 24, that green space ordinance precludes pools from being in the front yard. Okay, that's the town's argument. So if pools are excluded from the front yard, then Veronica and Marcia, your argument that fences that are allowed under 151B can't be, that argument doesn't jive, all right? But that's only one of our arguments. But he's saying that argument doesn't jive because pools aren't allowed in the front yard setback, okay? They're allowed behind the 18-foot property line, but he's saying that they're not allowed in the front yard setback, contrary to 85-51B. So how does he get there? So what happened is, he cites ordinance number 843. And Fred, I'm sorry I'm stealing your thunder, but I'm sure you'll have plenty to say. He gets to ordinance number 843, which I believe he has provided in the materials. All right. I'm a pointer, so I'm having difficulty with this. So this ordinance was designed to, what is it, number says? I'm gonna have to get up here, guys, so I can read it. This ordinance addresses green space. It changed the definition of green space. So in your code, I can't remember what article it is it Article 1, you have your definition?
Yes.
In Article 1, you have a whole definition section, right? And then that's different from 185, which is the zoning code. So this ordinance that was adopted in 2024 says, defines green space, all right? And it talks about, when parking, what parking you can have. And then it amends the Balk 2 zoning requirements, all right? And in Fred's materials, he has pointed to section 4 of this ordinance with green space. It says that the Balk table has been changed to say planning, green space, and open space requirements. And he's pointed in his materials to the language, all front yard area shall be green space, except for one 20 by 18 driveway space, or two 10 by 18 driveway spaces, and one 4 by 18 space for a walkway. All right? So he says that section precludes a pool. Okay? Because clearly from their definition, if you have to have green space, and we have the definition of green space, and that is in definition section, but take it from me, green space is green stuff. And a little bit of mulch here and there that is allowed around the trees. Okay? So Christina, we don't need to go back to it. Okay. But I do want to go to the box standards table. So keep going. Keep going.
Oh, you want the last one?
You got it. All right. So when that 843 ordinance was adopted, what happened is the language in section 4 of that ordinance got put in this bulk standards table that is attached to your ordinance. And it talks about, okay, when can you have greens, what are the green space requirements for something in an NR district, which is what Marcia is. And the town's argument is, okay, well, because you can only have a parking spaces, and you pick your poison on your parking spaces, you can have 2 or you can have 1, and a 4-foot walkway, you can't have a pool in the green space. But that argument completely ignores the rest of the code. And that's why I had the town stipulate to the fact that the town still allows a hedge, wall, or fence at 3 feet in height in the front yard setback. It still allows porches, platforms, paved terraces in the front yard setback under 18549D, and it still allows projections in the front yard setback. But if you read that language that they're pointing to say, this only prevents pools, okay? If you read that, if you take it to its logical conclusion, it prevents everything. It prevents fences, it prevents platforms, it prevents decks, it prevents other protrusions. All right, so all of those things we stipulated to, if you read this language exactly word for word, it includes all of those things. But the town isn't saying you can't have those things. What they're doing is they're selectively using this section to say, Marcia can't have a pool in the front yard setback, not allowed. So they're taking a very selective reading for their benefit, and not for their benefit, to support their argument, okay? It's a very selective reading, and it's a very unfair reading, because if you take this to a logical conclusion, everything would be denied. So my point on that is that as the BOA, you should not accept the town's interpretation of green space to contradict the clear read of 18551B, because that interpretation is, if you take a literal read, it prohibits everything, and the town is selectively pointing to that provision to say, no, hedges or fences aren't precluded, porches and platforms aren't precluded, but pools are. Okay, and that's just not a fair read of that provision, unless they're going to read it fairly across the board. Next thing I want to talk about is this ordinance. So you've heard the town say, and you've heard Kate Banzak.
Sorry, Kate, I always screw up your
Is it Banzak?
pronunciation. What's that?
Banzak?
Close enough, Banzak.
Banzak, I'm sorry, Kate. So Kate had indicated that this ordinance, that she had gone back to the original ordinance that was ordinance number 14, which was adopted, I believe she said, in 1983. Were you born then? So in any case, she says she goes back to that original 1983 ordinance, and that ordinance includes instead of saying required yard, says rear yard. And we also pointed out that that ordinance said 4 feet, and now the ordinance says 4.5 feet. I am having difficulty with the town trying to say that since 2009, when this ordinance was adopted, there is a mistake in the code, all right? And you guys should have accepted the position that, well, a pool was never intended to be in a front yard, all right? It's now 2026. This was adopted in 2009. So that's my number one problem with that argument, okay? It just doesn't seem fair. I mean, if your citizens cannot rely upon what's in your code, okay, that's been there since 2009, how can any citizen know what their rights are in this town? So the other thing I want to raise is that this new ordinance was formally adopted. This wasn't a section where this section was just codified, where an ordinance passed and Kate sends it up to the code company and they stick it in your code, all right? This ordinance that was adopted in 2009, which was ordinance 634, which we brought to your attention, the town actually adopted it. They attached it. They signed, it was signed by the mayor. They adopted it and said, hey, we're adopting this. That ordinance had 2 changes from the 1983 ordinance. Okay, it dropped the word rear and it changed the fence from 4 to 4.5. Now, I don't know about you, but I expect when my town council adopts an ordinance and they sign and they vote on it, that they've read everything in that ordinance and they've accepted it. All right? And there's case law that says the code is positive law. A change in the law by codification rather than by a specific amendatory act has the same effect. All right? So the code is the code. All right? They adopted it. It's the law. And I want to reference Checker Inn, Inc. at 229 A 2nd, 22, 1967. I'm going to skip argument 4 for now, and we'll see if Fred talks about it. And I think I'm going to save the rest of my arguments. Most of this is going to address Fred's rebuttal. Let me just say 2 things before I stop. We said that the rules of statute, that this statute is unambiguous. We believe that the code clearly establishes a fence separate and apart from, a safety fence is a fence established separate and apart from a normal or ornamental fence. And we think 185-51 clearly articulates that it's a totally different fence. But if you find that the ordinance, or these ordinances read together are ambiguous, the law says you've got to find in favor of the landowner. Fred argues 2 things, or the town argues 2 things in its submission to you. Number 1, it says, he says that if there is an ambiguity, that the applicant assumed the risk of that ambiguity. And we submit to you that that is absolute nonsense. The town has not had a decision in 2013 that Marcia testified to that allowed her to keep a fence in the front yard at section 1 at 114 Chesapeake. There was subsequent litigation about it, okay, when the town tried to basically revoke her permits again. The town never sued her to enforce the fence, okay? They never amended the fence. So the average Joe is going to assume that what they got at 114 Chesapeake, if it was allowed there, it should be allowed now. The other thing he also says that there's no ambiguity because the green space settles the issue completely about whether a fence is allowed. And for the reasons we discussed about why the green space ordinance should not be interpreted to negate this fence, I just want to reiterate that point again. So I'm going to save the rest of my points for the discussion. And Fred's argument does reference Ocean Bay Mart, and if he goes into that, I would like to distinguish that as well.
All right, but we're gonna give you very little time, because it just took 25 minutes. Mr. Townsend, you're not gonna take more than 25 minutes, right?
No, I'm not.
Okay.
I do feel like I might need to be standing up and pointing also, so I'm going to testify here. Thank you for your efforts tonight. I know you've been board members now for a while. I don't think you've been assigned as much homework as you were before this one. And you might get a reprieve. You might not have a test tonight. You might be able to study further for the test in 2 weeks or so. So thank the three of you and Mr. Forston as well. I do have to start with a couple of arguments that Ms. Faust made in her papers that she didn't address a great deal here. First of all, that the town can't deny this permit once they've given an indication that they were going to approve it. But that's just not supported in the law. The permit was never issued. And the fact is, the law allows that even a permit, when it's issued, if it was issued incorrectly, illegally, which is the question for you, whether it's legal to have a 4.5-foot fence in the front yard, that permit can be revoked. Any permit can be revoked so long as a certain test can be met. And that test is, whether expensive improvements have been performed. Expensive improvements have been performed. There's an example of the Miller versus Board of Adjustment case where my dentist, Dr. DeKine, back in the 80s, got a permit to move a house here in Dewey Beach from one lot to another. That house was legal non-conforming where it was, and he thought it would be legal non-conforming where it was being put, and it wasn't. But he had a permit. That permit was pulled, and that matter went through the courts, and I don't know the outcome on the street, but the courts did not accept the argument that the permit had to be enforced because it was illegal. The same is true with regard to the Shelburne case, which I think is the leading case on permits that are issued. In that case, in Rehoboth, there was a neon fence constructed with a permit. After it was constructed, it was determined to be non-compliant with the code, and the arguments that are being made here were made there, and they were rejected because the property owner has an obligation to know the code. And in this case, this property owner really did know that there was an ambiguity in the code. Because if you look at the materials that were submitted, there's no way you can read them and conclude that council or a board of adjustment or anyone said it's clear that you can have a pool in the front yard and therefore you can have a fence in the front yard. That was not the holding. The holding was, there's some ambiguity here, we can't resolve it. Well, that was their decision in 2013, and the rules of statutory construction require that if you can't resolve an ambiguity, if you're gonna give the government the right to regulate people's use of land, then you better be precise. So the rule of statutory construction requires that the landowner wins in the case of a tie, if you will, if you look at it that way. If there's an ambiguity, the government can't prevail. Well, that's what that Covington case, the Covington case is different, that was cited, but the Covington case was an actual change in the law. And there are standards set for changes in the law, and you're right to rely on the law as it stands. But this applicant had no fair understanding of what the law was when she brought this application for a building permit at 101 Carolina, because she knew it was ambiguous. And because it was ambiguous, she doesn't have vested rights under the law. The permit never issued. She has not constructed a pool. She built the house where she built it, and that was her decision. But she can't look back at 2013. And there are no examples since 2013 where the town has ever said, sure, you can have a pool in the front yard, or you can have a fence 4.5 feet in the front yard because it's a pool fence. There are no examples of that. So is that precedent? There's one instance, and that's 2013 where that happened. You know, as board members, that you don't, you're not required to follow precedent. You don't publish your opinions. You're not law trained, with the exception of our chairperson. But that's not your responsibility here to determine what the precedent is and apply it. Sure, the town should be consistent in their interpretations of the code, and actually they have been. Their interpretation of the code is that you can't have a pool fence in a front yard, and it's always been that. So the precedent argument falls by the wayside. So let's then turn to the issues that I was tasked by Mr. Forston to address, and the statutory construction issues. First, if we look, first of all, I think we all understand that maybe a layperson might think the front yard is something other than what the code indicates, but the front yard is that restricted area, the required front yard. It's 18 feet deep. If we turn next to 92. Okay, what is the meaning of ornamental in that sentence? If you look at the title, it's section 185.92. The title is fences. It's not ornamental fences, it's fences. And it indicates in subsection A that ornamental fences or walls may project into or enclose any yard, provided that, one, no fence or wall, period, no fence or wall shall exceed 7 feet in height. And then two, no fence or wall exceeding 3.5 feet in height shall project into or enclose any portion of the yard within the front yard setback. So that's clear. No fence. Doesn't say ornamental fences. If you look at my exhibit, I did not include in this slide the balance of oh no, I'm sorry. That's a comment I need to make with respect to the next slide. But 185.92 is clear. It relates to fences, and it says no fence or wall shall exceed 7 feet in a side or rear yard, and no fence or wall 3.5 feet or taller is permitted in a front yard setback. How do we reconcile that with the reading of the code? Well, you have to argue that it doesn't apply, but not sure how to do that. I think ornamental fences under the code are probably distinguished from those fences that aren't permitted. And they are fences that are described as wire fences, chain link fences, I believe, and other sorts of fences that aren't permitted. So that's what I think is a fair reading of the code. That's an ornamental fence, a fence that is distinguished from a chain link fence or a fence that's not otherwise permitted. Let's go to the next slide, please, Ms. Benezak. Okay, so here's the rub. A hedge, fence, or wall not more than 3.5 feet in height may project into or enclose a required yard or front yard to a depth of the street line. So this is a code provision that again is consistent with subsection 92 of 185, and it just lends additional support to the reading that we can't have fences taller than 3.5 feet in the front yard. The public policy behind this regulation is in part probably aesthetics. We don't want to see 7-foot fences, barriers obscuring the house, but it's also it's also a public safety issue, that houses up along roads, cars turning, people walking, their view of patrons, a driver's view of a patron and a patron's view of a driver can be impacted. I've got a false separation there at the second paragraph that I inserted, but that is indicating that, or it just shows that the 7-foot height applies to all fences that are in other yards, and that the drafters of the code are willing to say that certain fences in those other yards are not permitted. But there's no reference to, they don't do the same thing with regard to pool fences. The height limit does not apply to fences or walls used for commercial screening or tennis courts. So they're not saying that they're not implying that this is the restriction that applies to ornamental fences. They're saying this is the restriction that applies to all fences. And for that reason, we have to go ahead and indicate that commercial screening and tennis courts are not regulated by this restriction. Okay, one more slide, please. Okay, this is the language that is creating the rub. The accessory, what the applicant is asking you to do is to read, and this is their own highlighting. They're asking you to give meaning to just those first 3 words, and then the other highlighted words that follow may occupy a required yard. So accessory swimming pools, in their opinion, may occupy a required yard. Well, what they're asking you to do is disregard the presence of the word side yard, disregard the intent of the ordinance, which is to give some protection to neighbors at the sides and the rear. I mean, why would the neighbors at the side and the rear and not the public on the sidewalk be entitled to some kind of protection from the nuisance associated with a pool? It just doesn't make any sense. There's no logic behind it, and that's why council, when presented with all this information, noticed a public hearing on a resolution, which public hearing took place on, I believe it was January 16th of this year, to go ahead and commence the process of amending the code and reinserting that word rear. So the first step of that process was to notice the public hearing 2 weeks in advance. That was followed by a January 16th, 2026 public hearing in which the pending ordinance rule was invoked. So under the pending ordinance rule, with regard to applicants who have a right to rely on the state of the code when they file their application under that Covington decision, they arguably they beat the clock. They're in ahead of time. But we don't have a state of the code to rely on. And that's what the decision was in 2013, that it's ambiguous. And that's what the Ocean Baymart case says, that a pending an ordinance that follows a matter that was deemed ambiguous can be applied, because the property owner doesn't have a right to rely on the state of the law when the applicant knows that the state of the law is ambiguous. It's very different than if we had simply said, okay, you can do this today and you can't do it tomorrow. There were no examples of the town saying you can do this after 2013. There's no history of allowing it, and no one's ever asked to put a pool in the front yard. It is an absurd contention that pools are allowed to exist in the required front yard. There aren't any. No one's ever. There's Mr. Dedes testified there's 2 pools in town that are located in front of the house. Neither of them are in the required front yard. My papers go. So I mean, I would in response to Mr. Porson's question, I think this ordinance can be held against this applicant. I don't think it has to be, because I think it's apparent that this language can't be interpreted the way that it's being proposed to be interpreted, because if the word rear was removed on purpose, if they wanted to allow pools in the front yard, they would have said something about front yards. They didn't say anything about the front yard. This language doesn't speak to the front yard, okay? It only speaks to the side yard and the rear yard. And they wouldn't have left in the language "or side yard." They would have not said a required yard. They would have said any required yard. The applicant wants you to interpret that to mean that a swimming pool may occupy any required yard. So now, what we didn't know at the time, I mean, the argument they made in 2013 is nuanced. They weren't saying that a fence a 4.5-foot fence can go in the front yard setback. They were saying a pool can go in the front yard setback, and ergo, a pool fence can go in. Well, a pool is not allowed in the required front yard. The green space ordinance forbids it. Now, there are other code provisions that allow, for instance, fences in the front yard. The green space ordinance does not prohibit a fence from going in the front yard. The green space ordinance is addressing matters involving trying to prohibit impervious surfaces from being located in the required front yard and not having more impervious surfaces elsewhere than are absolutely necessary. So the green space ordinance clearly would prohibit a fence or a pool from going in the front yard. And absent a pool going in the front yard, then there's no argument that a fence of 4.5 feet height can go in the front yard. That's an argument of convenience that was made in 2013. It's an argument of convenience now. There's no way to read this language, the language of 51B, in a manner that's consistent with 51A or 92. We can't say for certain that we know. I mean, it's not fair of me to say we know it. We know that that word was not transcribed and should have been. But council fixed it. Council considered it a housekeeping ordinance, and they made the fix. And that's why if the applicant wants you to take into consideration what the council did in 2013, well, take into consideration what the council did in 2026. They adopted an ordinance to reinsert that word rear, and that gives meaning to the sentence, the meaning to the provision that didn't exist previously. I think that this board is free. This board is authorized to settle legal disputes like this, to evaluate the interpretations made by council and come to its own conclusions. You're not bound by precedent. You're not bound by the 2013 council. You're not bound by anyone. There's no evidence in the record that suggests that this decision was made or taken out of the town manager's hand or taken away from Mr. Eady's political pressure, though it existed, perhaps, was specifically addressed by the town manager as not playing any role in the decision making. And you heard him testify. You can judge his veracity. I think I've addressed the questions that I was asked to address. If there are any questions of me, this may be the last time. Not tonight. Okay, so be prepared to stand for questions later.
That wasn't 25 minutes.
Nope.
Sorry.
Ms. Faust,
I'm going to do 5 minutes.
I'll hold you to that.
Thank you. First of all, the application pool permit Ms. Scheck submitted, pool is not in the front yard, all right? The pool is not, remember what front yard definition is. It is not in the front yard setback, and that's the definition of front yard under the code, okay? Her pool is within the building envelope on that property, all right? just like the pool, it's a few houses down from her is in the building envelope. Okay, the one that has the 6-foot fence that they showed, her pool is in the building envelope. The only difference is her fence is in the front yard setback, the 4.5 feet fence is in the front yard setback. The only thing we're talking about tonight is the fence. And the town keeps saying that, it's absurd to think that pools are allowed in the front yard. Well, that's exactly what 185-51B says. Now, they want you to go back and say, oh, this was a mistake, the code was misprinted, but that mistake has been there since 2009, and the town has not done a thing about it, and they've known about it at least since 2013. They never sued Marcia regarding 114 Chesapeake to say, hey, your fence is in the wrong place, we're going to enforce this. They didn't amend the code, so the town has acquiesced. And to come back now, this many years later, and say, hey, this code was wrong and it's been all along since 2009, and your interpretation should be based on that, somehow that just doesn't seem fair. I mean, shouldn't we expect more from our government? Shouldn't we expect that they're going to make the rules of the road clear? And if they know that an ordinance is ambiguous, that they're going to fix it? The last thing I want to point out is Mr. Townsend speaks a lot about, well, the code means this, or the code means that, or the 3.5 feet is obviously a safety issue, and this was a legislative intent. There's been no evidence of legislative intent. We have no evidence of what the code drafters meant when they drafted these codes. All right, so the best all of us can do is read the plain language of the codes and try to interpret it the best we know how. So there is no, that's all we can do. And that's it. And thank you very much for your time, and I know it's very late.
Thank you.
Thank you.
I appreciate it. So, as I indicated before you all started, I want to continue this meeting. I'm looking at 2 weeks from today is the 14th of May. Can everyone pull out their calendars and see if they're available at 6 o'clock on the 14th?
So,
14th of May, 2 weeks from tonight.
14th of May. No, it's,
2 weeks from tonight, it's Thursday,
yeah. What time?
6 o'clock.
So we've got a problem with Mr. Dedes being here. Congratulations.
Yes. Well, I don't expect we need any more testimony from Mr. Dedes.
So it looks like I can be here.
Okay,
I'm good.
okay. The
I guess
committee's-
Mr. Forston's already indicated he could do it.
Okay, so it looks like we're all good for 6 o'clock on the 14th. We will continue this. We will, if the committee has any questions, we'll ask them. We will read into the record the public comments that we've already gotten. If any other public comments come in via email to the town, we'll also deal with those. Since we're not closing the public hearing, any members, anybody who is either here in person or watching virtually will be able to make any comments that they have at that time. Then we'll close the public meeting and the board will have its discussion with the assistance of Mr. Forston. So on that note, do I have a motion to adjourn?
Motion to adjourn.
Second. All in favor? All right. Thank you, everyone, and we'll see you on the 14th.